Mr. Bora, at two.
I'd like to mention item number 16, my lord.
Huh?
Because of personal difficulty, as Bharali is out of station, taking an adjournment.
Who is out of station?
As Bharali.
Okay,
Item number 16, my lord.
but this is of 2022.
Yes. Criminal appeal 298, my lord, 2022.
Huh?
Criminal appeal number
Huh,
298.
we'll have to take this up and then we can pass an order. Matters prior to 2023. We take up the matter, we'll give you the time. We are not taking up the matter on merits today, but we'll have to take up the file and see what is there. If it is something very simple, we'll look into it.
Hello, I'd like to mention one item, madam. The item was filed, revision was filed on Monday, madam, but item has not been listed. May I please, the item may come up tomorrow, madam.
Tomorrow is a Thursday, let it be on Friday.
Madam.
Friday?
Item number 23.
23. Yes.
2020, madam, sorry.
20, yes.
Yeah, madam, I have to file rejoinder affidavit, madam. Kindly 1 week time may be granted, madam.
The counsel for the petitioner has submitted that he would be required to file a rejoinder to the affidavit, to the objections filed by the state, by the respondent number 2. List this matter after.
Sir, in January, madam.
Well, then we have received the CD,
Ah,
then CD may be written back and after that CD may be. called.
item 20,
Yes,
criminal petition.
Official CD was.
Okay.
it is there.
List this matter again on 21st of January 2026, enabling the petitioner to file the rejoinder, full stop. The learned PP is requested to retain the CD. No, to procure the updated CD in the meantime.
Okay.
No, we have given 21st of January.
May please, your worship.
Yes,
So with the consent of the other side, I'd like to mention item number 17, madam.
1/7.
1/7.
Hmm.
It may come up after 2 weeks, madam.
The learned counsel for the petitioner has prayed that this matter may be listed after 2 weeks due to personal difficulty, full stop. Accordingly, list the matter
After
in
2
the
weeks.
last week of January
Madam.
2026.
I'm deep.
Wait, please, your lordship.
Yes,
Item 7, we have filed a.
item?
Item 7, lordship, we have filed
Seven.
an additional affidavit.
Ah.
May be called.
Yes, yes.
May I please, your lordship,
Huh?
for listing a regular bill application, motion matter, lordship, tomorrow, lordship.
Friday.
May I please, the lordship, I like to mention item number 2.
2.
Item number 2. I have filed an additional affidavit on behalf of respondent number 2. Maybe we can have tomorrow,
Call for it.
listing.
Why, if you have filed it, then we can have it today also. Okay, 2.
Item 2, I'm for the petitioner, madam.
Huh? He is filing an additional affidavit or something.
This is motion case, let the item reach.
Let the item reach, or you can even, motion matter, for a respondent number 2, I'm not understanding. Let us see, let the matter reach at item 2. Yes,
Yes.
let the matter reach, yes.
May please, your lordship, lordship, I beg to mention item 47, lordship.
47.
It's a criminal revision petition. your
Huh?
lordship. Criminal revision petition, your lordship.
Huh?
Lordship, we had a newly engaged counsel here.
Hmm.
So lordship may kindly grant us some time to find a vocal.
We have to wait, we'll take the matter in hand. It's 2014.
Yes, lordship.
We'll
but-
have to see what the matter is
But
about.
your lordship, we have only newly engaged. your
We
lordship, and-
will record that statement when the matter reaches, but we must know what the matter is.
Yes.
Explain to him. Yes,
May I please, your lordship, I beg to mention item number 46, madam.
Huh?
From hearing column, madam. Can this matter be taken after vacation, madam?
we'll take it up when the matter reaches. We will not put you to a disadvantage.
Okay.
Yes. Hmm.
May I please, your lordship. The bail application, certificate matter certificate, and the FIR is on page lordship 11. The whole story is concocted, lordship. And there is a contradiction in the statement recorded. The actual fact is that the victim girl has some love relationship with another person, Lordship.
Huh?
The victim girl has some love affairs with another boy,
Ah,
and that boy have some enmity with the petitioner, Lordship.
yes.
And that's why, as per the dictation of the boyfriend of the victim girl,
Hmm.
the victim girl lost the affair. Can we see the statements, Lordship?
Without notice to the informant, we will not consider it, but yes.
As page 28, particular one, the statement of the victim, Lordship. সি মোবাইলেৰে মোৰ মূৰত 3 বাৰ মাৰোতে তাৰ মোবাইলৰ লাইটটো জ্বলি যায়, তেতিয়া মই তাৰ চেহেৰাটো দেখো। সি মোৰ
Page
হাতত ধৰে
40?
আৰু ধৰি সি কয়, মই ৰুবুল নিচিঞৰিবা,
Ah,
like that, Lordship.
hmm.
So one person come to rap with the victim girl,
Hmm.
and he give his recognition by saying his name. That's I am Rubul, Lons South.
Where does it say so? Moi rubul, মোৰ হাতখন ধৰোতে সি মই ৰুবুল নিচিঞৰিবা এইদৰে কৈছিল। So
And at the statement given by her grandmother, Lordship, page 33,
hmm.
particular one, Lordship. মঙ্গলবাৰ নে বুধবাৰে, just giving the statement before the police on 5th of October, and 6th of October, he give the statement before the magistrate, and he does not properly recognize the date. মঙ্গলবাৰ নে বুধবাৰে ৰাতিপুৱা 11টা মান বজাত আমি শুই থাকোতে সি আমাৰ খুৰা খোৱা কথা লৈ আহিছিল। সি বিছনাৰ ওচৰলৈ আহি মোৰ নাতিনী গায়ত্ৰী কলিতাৰ লগত কাজিয়া কৰে।
Hmm.
সেই সময়ত মই আৰু গায়ত্ৰী একেখন বিচনাতে শুই আছিল। তাৰপিছত ৰুবুলে যেতিয়া গায়ত্ৰীক বিচনাৰ পৰা টানি নমালে, তেতিয়া তাই চিঞৰি দিলত মই সাৰ পাই চিঞৰ বাখৰ কৰোঁতে ৰুবুলে গায়ত্ৰীৰ মূৰত তাৰ মোবাইলটোৱে মাৰি দিয়ে। যিহেতু সেই সময়ত আন্ধাৰ আছিল, সি পলাবলৈ মোবাইলৰ লাইটটো জ্বলাওঁতে আমি তাক চিনি পাওঁ। The whole stories are making one, Lordship.
At least he was there at the night, trying to grope.
No,
Cool.
Lordship. He is denying that he is coming.
Heard Mr. M.K. Nyok, learned counsel appealing for the petitioner, also heard Mr. Parashar, learned APP, full stop. This is an application under section 483 of the BNSS in connection with Dhokwakana PS case number from page 1, huh? So and so. Issue notice to the respondent number 2 as per the prevalent notification, full stop, call for the CD list the matter again on yes, when
Lordship, before the vacation, 9th of
Before vacation notice.
10 days
how
we
notice?
cannot, huh?
Notice will not serve.
Reopening on কিমান সোনকালে দিব পাৰে দিয়ক? 8th of January.
letter certificate, Lordship. Can we
Yes,
mail
scan copy and
the
scan,
Huh?
scan.
Scan copy of the TCR. 8th. I must have said CD, say scan copy of the TCR, huh? Yes, item 2. Someone was making a mention.
Maybe, I think.
Yes.
2, my lord. Can you come up on Friday, my lord? On
Huh?
12th, my lord.
In the morning, you were saying that we take it up
I did not have any instructions, my lord. I called my senior, my lord.
Huh?
Can you come up on Friday, my lord?
Friday at the request of the learned counsel appealing for the, Petitioner.
Possibly the informant has entered appearance, my lord. I did not know.
from where, how does she know
now-
there's a bail petition pending?
No, no, my lord. They are to be married, my lord. The boy and the girl, my lord.
One person came and he said that he objection file and.
Not objection, he's saying he's filing an additional affidavit.
Additional.
Yes, my lord.
Let me assure you what kind of an additional affidavit it is. It is that I do not have any objection. Find out whether the compensation has been paid the victim. This kind of thing has to stop.
My lord, can you come on Friday, my lord?
Friday, at the request of the learned counsel for the petitioner, list again on Friday.
Oblige me.
There is a certain, this thing going on, Mr. Parashar. We are noticing in POXO matters. You are appearing?
With my lord's permission, my lord, if I may just indicate,
Huh?
item number 3, I would be appearing for the informant, lordship.
Hmm.
My daughter had committed suicide by hanging,
Hmm.
and the allegation is of rape.
Hmm.
So far as they are concerned. This is a motion matter.
Uh,
We'll be filing the hearing. I just got to know that this was filed. Anyways, so far as item number 29 is concerned, of the same FIR,
Same FIR, Lord.
another co-accused,
TCR
that
is
is-
there.
the records are there. That is there. And another matter of motion, item number 50, I presume, of this third accused, where I am appearing. May I pray in the fitness of things, all these matters taken on Friday? Because I'll be filing a wakalatnama, my lord. That's more important.
okay, Mr. Esmanik,
altogether.
has appeared.
So far as 3 is concerned, I would be filing in some time.
So so far as item 3, huh?
3 is concerned.
Has submitted that he has instructions to appear on behalf of the respondent number 2 and would be filing the wakalat number during the course of the day. It has been further submitted at the bar that item number 49 and item number 50,
Lordship, 29 and 50.
29 and 50 arise out of the same FIR and are listed today, full stop. He has prayed that all the 3 matters will be taken up on Friday so that his wakalatnama is on record in item number 2 also. Full stop. Learned Counsel appearing for the other matters.
Lordship,
Do
I am
not,
for 3 also.
do not object for the, object to the same. We'll have it on Friday.
He's for 29 and 50.
29 and, 50. Sorry?
If possible, madam.
Objection
part,
Which objection?
No, he's saying that he has not considered that maybe in the.
Oh, acha,
It
acha,
has
acha.
passed.
Although the learned counsels, although the learned counsel appearing in the item number 29 and 50 has submitted that the other matters will be taken up today, comma, in the fitness of things, this court directs that all the 3 matters will be taken up on Friday.
In the bail hearing also.
Same thing, motion
Same.
pending will come together.
Wherever it is, we'll take it up together.
In the.
We'll
Ah.
take it
Yes.
together only. 29, 50.
Yes.
In the bail hearing column, how does it matter? It will be before this court, will take up all the matters. 329 50. Tinta take a order.
In the event of I will supply him the copy. It's
29 and 50, you write? In view of the order passed in BA number 3976 of 2025, list these matters again on Friday in the bail hearing column.
Grateful, man. Obliged.
Obliged.
Yes, madam.
It's a POXO matter of, again, lordship, but the problem is that, my submission is that, lordship, in the FIR, my name was not there. Only it was written that the staff of the so-and-so bhavan was involved. And I was a service boy only of that bhavan, lordship. In last 45 days, I am behind the bar, lordship.
We'll have it as soon as possible on the reopening, because without the respondent number 2, we are not in a position to pass any orders once POXO is involved, na? Okay, bail application 483, page number 1, Bilasipara. PS case number so and so. At the top, you'll write heard Miss S. Kananguha. Then the counsel paying for the petition and also for the and so for the so and so. Additional PB, full stop. Issue notice on the respondent number 2 as per the prevalent notification, full stop. Charge sheeted, no.
No, no, no.
Not facility.
Call for this, call for the case diary. List again on 7th.
Wait a minute.
Yes, sir.
No, it is an NDPS case. The quantity is commercial quantity owner, where 10,000 tablets of Yaba tablets were recovered.
10,000.
10,000 Yaba tablet.
If it had some medicine, we could have,
Scan copy mein call-
Charge sheeted, yes.
Yes, Your Honor.
Heard Mr. So and so. Also heard Leonard APP. Petition under section 483 BNSS. Praying for bail in connection with NDPS case number 360. Pending in the court of,
Additional district and session judge norm 2.
Huh?
District and session judge norm 2.
number 2, what? Which district? Kamrup. Kamrup Metro. Kamrup Metro, full stop. Call for the scan copy of the TCR. List again on.
Commercial wholesaler.
What I was thinking is if it was some normal medicine, we could have supplied to some hospital.
Yaba.
So if it had been some medicine with this quantity, yes. When?
21st.
21st of January.
6.
Yes.
Lordship, madam. 35 days behind the bar, my lord. It is intermediate quantity of tramadol, my lord.
Hmm.
FIR page, my lord. 15, my lord. It's a very long FIR, my lord, but two persons were apprehended.
Father and son,
No, no, my lord. Yes, my lord.
father and son.
Yes, we are. my lord. The FI name accused, they were carrying tramadol, my lord.
How
1 kg
much?
tablets, my lord. We are not the FI name accused persons, my lord. In between Lordship will see, my lord, on reaching the spot that is near Hakma HP petrol pump,
Hmm.
National Highway 7, two persons as pointed out by the source were found loitering. Suspiciously, accordingly, they were apprehended. On being inquired, they revealed their name as Sirajul Islam, son of so-and-so, and Sofiur Rahman, my lord. Recovery has been made from them, my lord.
Hmm. Why are you arrested?
My lord, down below, Lordship will see, my lord, description of article seized, my lord.
Ah,
This 87.38 grams, my lord.
total number of so and so, each strip contains 24 number of tablet, net weight 87.38.
87.38.
Yes.
However, my lord, Lordship will turn to page 19, my lord. The magistrate's order, my lord, during inventory, my lord, the weight was, actual weight is 69.6, my lord. This is also intermediate quantity, my lord.
Hmm. No, why are you arrested? You are
I
these
was
two.
arrested on the statement of the FI name accused persons, my lord. Lordship will turn to my forwarding report on page 24, my lord.
Page 24.
But
Hmm.
only on the statement of the four accused persons, my lord. Nothing has been recovered from me, my lord.
Page 24, during interrogation previously arrested accused persons,
Purchased
stated
the-
that they have purchased from this Babidul and Matiur Rahman.
Yeah.
Okay.
Now grounds of arrest, arrested accused person, habitual drug peddlers, and they have previous case record. Bilasepura PS case, so and so and so. That is also NDPS, my lord.
Yes, but that is true.
So,
But Lordship will
my lord-
kindly appreciate one thing, my lord. Page 24. No police custody was sought for, my lord. I'm behind for 35 days, my lord.
Ah.
60 days of mandatory period, my lord, and only allegation against me is statement of co-accused, my lord. And that is not admissible, my lord. Had something been recovered from me, my lord.
May on
May I play
Huh?
this? Only one thing I'll
Could
play.
be at this case.
Let the CD come, we'll have it.
This Lordship will see, my lord, even in quantity cases, my lord. If
See,
it's
the
only
thing
this
is,
co-accused, my lord.
I'll tell you something. First time offender, very little quantity,
Yes, my lord.
some inclination,
But-
very young boy, some inclination. But repeat offender, another case is pending, someone takes your name, that becomes a little bit difficult without the CD. Let the CD be here
The
if,
petition number 2, my lord, he's a young boy, my lord.
now we understand. But father and son together sitting and doing it is something we are not appreciating
18,
at this moment. Let the CD come, we find nothing against you, we'll go.
Otherwise, the thing is, my lord, during the vacation, my lord, the mandatory period will be over, my lord.
No, 18, my lord.
Huh?
18th.
18th,
18th.
18th.
Apply-
Pray for bail under so and so. In connection with so and so. Mr. Mahajan, counsel appearing for the petitioners have submitted that they have already
35 days. my lord.
completed 35 days in custody, full stop. The petitioners have been arrested only on the basis of statements of persons from whom contrabands had been recovered, full stop. The Land Council for the petition states that no recovery has been made from them and it was only on the basis of statements, full stop. In view of the above, call for the updated CD list on 18/12.
Obliged, my lord.
Or you can also write that the petitioners are related as father and son. Yes. You remember that then? Yes, we check. অলপ পিছত মাতি দিয়ক, বেলেগ photo আছে চাগে। You there? Yes, I said you.
May I please the lordship? My
Yes,
lord,
Mr. Gupta.
this is the regular bill, my lord, FIR at page 14, my lord.
Ah,
My lord, at this stage, I pray for the CD, my lord. It is from Baptista PS, my lord, nearby. So after 1 week, my lord. Offense under 318(4), my lord. The petitioner is not directly involved, my lord. The main accused is some other person. Petitioner is having a jewelry shop, my lord.
he cleans it, he's cleaning it.
No, my lord, but the article.
So how much time to clean? When? 18?
18.
15 ki tarikh?
শুক্রবার?
Next.
Can it be on 17th, Wednesday?
Okay.
Subject to his convenience.
Okay, my lord.
17th.
17. Mr. DP Boral and counsel appears for the petitioner. The red APP appears for the state. It has been submitted by Mr. Bora that the petitioner is not name accused in the FIR and runs a jewelry shop, full stop, and has been arrested only on the basis of suspicion, full stop. You have the above call for this updated case diary. List
Okay.
again on 17/12. Yes.
Obliged.
Wait, please, your lordship.
Yes.
Petitioner happens to be the owner of a vehicle, lordship,
Hmm.
and the driver unfortunately made it an accident. And consequently, this affair has been lodged, lordship. Lordship, may tell you, page 7, the affair, lordship, near it.
Hmm.
Lordship, meanwhile, lordship, I filed a GIMA application in the court below, and court below has given the interim custody of the vehicle, right? But because of the pendency of the case, and once the section is non-bailable section, so petitioner is pending his arrest in the event if he appears to, because vehicle is a commercial vehicle, lordship, and that is the only means of his livelihood. That is why lordship is before this, and
You are the owner.
I'm the owner of the vehicle, lordship.
Vehicle.
This, and even the buffalo has already been, that the GIMA also been considered, so for my instruction. And the petitioners, vehicle.
Any,
handed
the,
over.
the Zima order is here, no?
No, but my vehicle's, GIMA has been, this order is here. So. Been considered, and I'm directed to APL.
Owner. Truck owner, some receipts are given here. That is another part. Now, 303 upon him, will it lie when the
So that is a.
driver was driving it negligently? Is it not? The other sections are available. Which one is not available? Huh?
Available, other two sections are available.
Which one? 281, 125B?
Yes, Lodge.
Available.
Yes, Lodge.
3032 is not available.
That is not their logic.
Huh?
That not approx also, look, because they claim that it is suspected to be stolen. It's not stolen because GIMA has already been considered.
Zimma for the vehicle has been considered, not for the buffaloes.
That,
Give us-
that order I'm not having, lordship. And the receipt of this ownership that was given to petitioner at the time of loaning, that I have filed additional affidavit, lordship.
These are regarding the buffaloes which were found there.
Yes, lord.
Yes, Mr. Parasar. 303 not applicable to him from any angle. Other parties again will, yes. Heard Ms. T. Som, learned counsel appearing for the petitioner, also heard Mr. K. K. Parasar, learned APP for the state, full stop. The FIR had been lodged on 10/11/2012, alleging that on 2/11/2025 at about 7:50 PM, the information was received at the information was received by the police that a truck of which the registration number was not known had knocked down one person near Kolitakuchi. Full stop. On verification, the driver and his associates were found absent from the vehicle, full stop. The vehicle was found to be loaded with 7 buffaloes, and it is also stated in the FIR that the victim of the road traffic accident had met his demise in the hospital due to the injuries sustained in the accident. Full stop. Ms. T. Som, learned counsel appearing for the petitioner, has submitted that the petitioner herein is the owner of the vehicle and is in no way connected with the offences alleged in the FIR. Full stop. She has further submitted that the cases having been registered under section 289/125 within bracket small b /303 within bracket 2 of the BNS and read with section 125 of the Central Motor Vehicle Rules and section 11(1)(d) of the Prevention of Cruelty to Animals Act, comma, the petitioner cannot be in any case be held to be involved in the non-bailable offence amongst the aforesaid sections. Full stop. The learned counsel has submitted that the petitioner has already been granted the zimma of the vehicle and also of the livestock.
Other person.
Okay. Of the zimma of the vehicle and the zimma of the livestock has also been given to its original owner. Full stop. She therefore prays that there is an apprehension that the petitioner may be arrested when he approaches the authorities to take zimma of the vehicle involved. Full stop. She therefore prays that the petitioner may be granted the privilege of pre-arrest bail in the matter so that pre-arrest bail in the matter. Full stop. Learned APP has submitted that has objected to the bail petition. Full stop. We have gone through the records. We find that the sections leveled, that the provisions of law invoked, not the sections leveled, that the provisions of law invoked in the FIR are all bailable save and except section so and so 3032 of the BNS, 3023 within bracket 2 of the BNS. Full stop. Since there is no allegation that the petitioner was driving the truck at the time of the incident, comma, we do not find that the said provision would be applicable to his case. Full stop. Therefore, this court deems it fit to grant the privilege of pre-arrest bail to the petitioner. Full stop. It is granted that in the event of the arrest of the petitioner, comma, he shall be released on bail on furnishing a surety of ₹10,000 with one surety of the like amount to the satisfaction of the investigating officer in relation to Hajo PS case number 475 of 2025. Full stop. Then you give those conditions of participating in the inquiry as and when necessary, and so on, not leaving the. Yes. Bail petition disposed of. Sign the whole idea. Whole idea. এখন এটা আপনি আপলোড করে ফেলেন। Yes.
The charge-sheeted case and the petitioner herein is the father and son worship. Worship, the affair page 10, it is regarding worship, in fact, the petitioner number 1 and the victim is the husband and wife. And one very basically lodged an affair saying that they are involved in child marriage worship. That is the basic allegation worship. Page 10 is the affair. So in this case, worship, subsequently charge sheet was laid and someone was issued, later on NBW was issued. That is why I am apprehending, and otherwise I am ready to appear and face that.
Why did you not appear when the summons were sent?
Yes, Lordship.
Why did you not appear?
During the investigation, he is absconding. Now, when NBW issued seeking.
No, on 5/11/2024, the summon was issued. Then the next order on record is 19/9/2025, which says both the accused persons remained absent for long and repeatedly petitions were filed seeking time for their appearance.
But kindly see one aspect, because the victim in petition number one, they are only husband and wife, they are living happily, Lordship. So Lordship, in that circumstances, Lord, they can do.
What circumstances will lead to what?
Because the victim, alleged victim,
Ah.
upon which the alleged offense was committed,
Ah.
she is with the petitioner number one, they are
Ah.
living husband and wife. So Lordship, in this case conviction.
Somewhere we had read that this husband and wife does not mitigate the
And Lordship, one
offense.
I have submitted.
Ah.
Perhaps,
rights of adolescents. What is that case?
no, Lordship,
Hmm? In re rights of adolescents, you are appearing for the wife,
Lordship,
huh?
I'm the respondent number two.
Huh? What do you say?
I'm saying, they are a husband and wife, so I have no any objection.
Marriage Solomon as well.
Huh?
বিয়া কেতিয়া হৈছিলে?
Yes, Mr. Parashar. We'll allow him to appear before the trial court. You go and appear and
Yes.
you pursue the matter there.
Yes.
Pray for regular bail.
22
There.
marriage Solomon.
Huh?
In 22 marriage Solomon as she is at that point of time.
Age 20?
2022 marriage of Solomon.
Huh. The issue is not whether he'll be found guilty, what happens to his fate is we are not concerned. The attitude of not appearing before the court. There are other ways and means to.
Can we, one aspect, on my part, Lordship,
Ah.
because there is a non-bailable offense, there is a apprehension of arrest.
Ah.
Because that is.
So
what we
in
are seeking-
September 2022, when the first summon was received, you should have been before this court,
Yes, Lordship,
or 2024.
yes. That's fair.
You have not even taken the pain to give us all the orders.
No,
And they should file a, if that is their, challenging the NBW order,
Ah,
both husband and wife may file a criminal petition under 528 for quashing the NBW.
whatever needs to be done, but
that's
now,
another aspect.
huh? Do one thing, we'll take this up again on Friday. Get us all the orders of the lower court. And also make a statement on affidavit
Yeah.
that the compensation to the victim girl has not yet.
Because they are a husband and wife already, petition number one,
Ah.
and the victim, they are living happily as a husband and wife.
Get us all the orders of the lower court.
Okay,
Because see, there in the lower court, you are not appearing on time.
yes,
Here before this court, you are not putting up all the orders.
yes, that's it.
One of the orders may contain a stipulation that absence on the next day will not be forgiven. Even then, if you have not appeared, it is to your risk.
Okay, right, right.
Every husband has a wife, every petitioner standing here probably has a wife. So the relationship of husband and wife is not the issue here. The issue here is your non-appearance before a court when summoned. That is the authority we need to impress. When called for, you go and attend. Is it not? Get us all the orders by Friday, we'll consider your bill. List this matter again on Friday to enable the learned counsel for the petitioner to bring on record the previous orders passed by the trial court.
Yes, yes.
Yes, get us all the orders that have been passed till today. Item 52, yes. Yes,
FIR is page 12 beyond.
page 12.
Allegation is that I am illegally transporting cattle
Huh.
outside the Assam to Malibari to Meghalaya to Bangladesh on foot, Your Honor. But Your Honor, I am the owner of those cattle and I have purchased those cattle legally, Your Honor. And I have annexed the purchase receipt also.
Hmm.
On page 20 onwards, Your Honor. And two co-accused person also granted bail. And I'm submitting.
Named affairs.
Yes, Your Honor.
Named in the FIR? Sattar Ali.
Sahib Ali.
No, Sattar Ali and another person is there. And Abid Ali.
Abed Ali.
These are the two persons from whom the cattle has been
And,
recovered.
Yes, Your Honor.
and after interrogation them, it came to know that namely Sahib Ali so involved illegal business of smuggling since long time.
Assessing those kettles, Your Honor, and purchase receipt was there. Page 20 onwards.
Then you must have sold it to these people.
No, Your Honor.
Then they stole it from you.
I am purchased those kettle for business, Your Honor, and
That is what, then you must be selling the cattle also. For them to be found with the other two people, Sattar Ali.
Sattar Ali also granted bail, Your Honor. Sattar and Abed also granted bail. I am Sahib Ali, Your Honor. Kindly, Your Honor, protection may be given and I will ready to appear before the investigation agency.
Mr. Parasar, what do you say?
Such type of cases subsequently when petition filed, all the receipts were come. It was not there in the instant. Subsequently, because there's FIR of 1711, all receipts are of 1511.
A day or two before it was bought and it was being transported. But here
On
these people were in custody, so the court considered the custody period
Yes.
while
Your Honor,
granting them bail.
on 16 days, Your Honor.
Huh?
Honor, transporting kettle to
We'll
Bangladesh.
call for the CD granting the interim, let him go and have his statement recorded
And
first.
let them submit this receipt before the.
Everything before the police, let them verify the same, come back with the CD. We'll grant an interim now. Huh?
Madam.
Yes, heard miss?
P. Kolitalo.
P. Kolita Learned Counsel appearing for the petitioner. Also heard the learned APP, Mr. K. Parasar, full stop. This is an application for grant of pre-arrest bail to the petitioner in connection with BOCO PS case number 353 of 2025 under section 13(1) into silo, page 1 or so. So and so the learned counsel for the petitioner has submitted that he is not a person in the named in the FIR and he apprehends arrest because he is named in the learned counsel for the petitioner submits that the name of the petitioner has been incorporated in the FIR only on the statements of two persons who were suspected to be ferrying illegal cattle. Who were suspected to be ferrying cattle illegally, full stop. The learned counsel for the petitioner has submitted that the petitioner has the receipts of the cattle which he had purchased for his agriculture business, for his farming business. Full stop. She further submits that the persons who were found to be transporting the cattle have been granted bail by the order dated 5/12/2025 in bail application number 3909 of 2025. Full stop. She therefore submits that the petitioner may be granted the privilege of pre-arrest bail so that they may, so that the petitioner may participate in the investigation process. Full stop. Heard the learned APP. Full stop. Call for the case diary. In the meantime, it is provided that in the event of the arrest of the petitioner, he shall be released on bail of rupees 15,000 with one surety of the like amount subject to the satisfaction of the investigating officer. Full stop. The petitioner shall appear before the investigating officer within a period of 7 days from today to have his statement recorded and shall also produce all documents that may be in his position to facilitate the investigation. এই বেল দিয়া পাৰ্টটো ইয়াত অললে লৈ আহিব। In the meantime, it is provided that list the matter again
29-1,
on
29-1.
29/1/2026. The updated case diary.
May I please your lordship? This is a criminal petition, lordship, filed for parallel running of two cases separately against the same cause of action. The accused person is also seen. Without wasting time, lordship may kindly directly peruse the page number 59. Page number 59, first order. In the
5/9.
5/9. In the top corner, lordship will find the CR case number 164. And lordship, now lordship, third para, the order dated 10/9/2024, third para. After such hearing and perusal, I have found sufficient grounds to proceed against the accused Hamidul Islam for commission of the offense punishable under section 498A. It means under 498A case has been going on. Now lordship may come to page number 72. Page number 72. In the top corner, lordship will find the case number, PRC case number 790 of 2022. Order dated 10/9/2025, third para. Finding sufficient materials against the accused persons, formal charges under section 498A/34 IPCR frame and read over and explain to the accused persons to which they pleaded not guilty and claimed to be tried. The 498A section now parallelly running in the PRC case as well as in the CR case, lordship.
We presume that you do not have two wives making two complaints against you.
No, no, no,
Hopefully.
absolutely not. And lordship, not only that, now lordship, again come to page number 59, the last para. There is no sufficient grounds to proceed against the other accused persons. Here, lordship, other accused persons means he includes the petitioner, petitioner number 2, that is the father of the first accused. Now, lordship,
One has proceeded on a, one has proceeded on an FIR lodged
yes, lordship.
and one is proceeding on a complaint lodged.
Yes.
Two different.
Two cases are.
Where is the
there.
FIR?
Yes, lordship. FIR, lordship. Translated copy, lordship, is at page number 21, Annex 1. 21, Annex 1.
Who has filed it?
The wife. The opposite party number 2 hearing,
Meena
the
Begum.
wife, the informant. She has lodged this FIR first. And 7 days later, she has filed that CR case.
Where, do you have a copy of the complaint?
Yes, lordship. The CR case copy is at page number 32.
30?
2.
What is 28?
This is in vernacular, and lordship type copy is at page number 28,
8.
Annex 2. This is the CR case. She lodged it after filing the FIR, and lordship, now what happened after filing the charge sheet? The PRC case is also running, and this CR case is also running.
There was an FR filed.
Yes, Lord.
Final
Firstly,
report.
she lodged the FIR. After 7 days, she filed a CR complaint case before the same judicial magistrate.
Yes, sir.
Now, lordship, same judicial magistrate is trying both cases together and not clubbing them. Now, lordship, what happened?
Where is that application for clubbing? Have you
This
moved an
applica-
application there for clubbing?
Yes.
Where is it?
The advocate appearing in the trial court.
Made us oral submission.
He instructed me that he oral submission and written submission also he has given, but that copy is not with us because he has given that to the court. So lordship may kindly call for the records, and lordship, in the meantime, both the cases may be stayed unless and until this case is heard finally.
No, not both the cases. You choose one of the cases.
Then
Choose
lordship-
either.
Then lordship, CR case maybe, because in the CR case, her pair was for recovery of the Steedhorn. And immediately after filing the CR case, Steedhorn has been recovered. Such warrant issued, Steedhorn
Then why the
Thereafter-
498 proceeding?
Thereafter lordship, now 498A is running in that case along with 406.
Yes, Mr. Parashar, what do you say?
406.
Same husband, wife, same court?
Right now, lordship,
What the case, my lord, FIR,
Cannot run.
FIR is directly for torture. And this for my lord, subsequent complaint case It's for street on.
No, no,
Complaint case-
what we are saying is that the court is proceeding on the orders so that the court is taking up both the cases
Under same section.
under 498A.
that is-
Now, what we can do is we can stay the PRC case.
Lordship, not only that, the father, the petitioner number 2 hearing, in one case, he has been discharged, saying that there is no material.
You
of
want a
498A.
disposal, sir?
But Lordship, in
Do you
another
want
case-
a disposal, sir? Listen to us. Listen to the full conversation between the PP and the judge. You will understand what is happening. Take that time. Take some time. If the PRC case is stayed, it proceeds in 498A against the first petitioner, because in the PRC, there is nothing. Also, in the PRC, the father is also
Yes.
being taken into account, while in the CR case, nothing against the other. So the petitioner number 2 is already protected once we stay the PRC. In the meantime, we issue notice, let them come, and we will give the liberty to the petitioners to approach the concerned court for clubbing of the matters together, so that in the meantime,
But
I'm here for quashing Lordship because.
we cannot quash it today.
FIR,
No, no, today I'm not.
We will concentrate on today. Heard
Lordship,
Mr. Swenson Learned Counsel appealing for the petitioners.
because Lordship, 406 is totally now not applicable in this case. And Lordship, 498A in PRC, it is running. I'm for
had it
quashing of
been, had it
CR
been,
case.
had it been in the
Because
case,
Lordship, because Lordship, Street on
You
has
are for,
already
you are for
revoked
quashing of the CR case,
CR case.
and you want the PRC to continue.
Continue, it may be continue. because
PRC he wants to continue. Little while ago, he said the CR should continue.
I just want to stop the trial of.
Which one?
406 and 498A. This is.
One
CR
of the cases, either the CR or the PRC
CR,
continues,
CR.
your choice.
Because Lordship, now.
Which to stop?
For CR 164, CR case to be
Okay.
stopped.
Take them. Heard the learned counsel for the petitioner, also heard Mr. K. Parashar, learned counsel appearing, learned APV, full stop. The grievance is in this criminal petition is that two proceedings regarding the same cause of action have been initiated against the petitioners at the behest of the opposite party number 2, full stop. The learned counsel for the petitioner has submitted that the opposite party number 2 had filed an FIR on 37/2022 before the officer in charge, Boitamari Police Outpost, which culminated in CR case number, what was the page number? CR case number 164 of 2022, where the petitioner number 1, where sufficient grounds to proceed against the petitioner number 1 was found by the learned trial court and for commission of offences punishable under section 498A IPC, full stop.
Along with 406.
The next date fixed as per the documents available with the petition was on 26/11/2024, comma 11/2/2025, 17/5/2025, and finally, the case is now fixed on 6/2/2026. Full stop. The learned counsel for the petitioner submits that 1 week after the filing of the aforesaid FIR, the complainant had also filed a complaint case which was registered as
PRC case number 790.
last page, man.
as PRC number 790 of 2022 before the same trial court, same trial court, comma, wherein formal charges under section 498A/34 IPC has been framed against the accused person, namely the petitioner number 1 and the petitioner number 2, Namzad Hamidul Islam and Yunus Ali full stop. The learned counsel for the petitioner has submitted that it would be unlawful if both the proceedings are allowed to be carried out before the same trial court based on the same set of allegations leveled by the same complainant.
Against the same.
Against the same accused persons, full stop. Issue notice. Extra copies of the petition be supplied to Mr. K.K. Parashar learned APP. Issue notice to the respondent number,
Two.
Opposite party number 2 through speed post.
Now it is speed post.
Through speed post, full stop. List the matter again on in February,
February.
20th of February, in the third week of February, 2026, on a date to be fixed by the registry along with service report on the respondent number 2. Full stop. It is provided that in the meantime, the proceedings in
CR case number 164
of
of 2022
22 shall be
Stay.
kept in abeyance.
That procedure malat 233 of BNSS malat
Ah.
when a complaint case, police case and a complaint case together,
Huh.
233 BNSS.
So, what is to be done?
Malat that is the thing malat. One has to be stay and subsequently the magistrate may club together malat. Calling for the report.
We'll decide it on the next day. Let the other person appear. CR is stayed.
Obliged, deeply obliged.
Please, your Lordship. Lordship, this application is filed for quashing of the FIR and the subject, Lordship. This is a matrimonial dispute, Lordship, which is amicably settled already, Lordship. We'll find the settlement agreement on page number 33. And accordingly, 3 cases will be withdrawn, and now the mutual divorce has been filed. Two dates of counseling has been already over, and this is pending, Lordship. Notice may be issued.
What were the allegations here?
He filed a complaint case which turned out to be a PRC case.
Both husband and wife are petitioners here. Who are the petitioners? Husband and wife together?
No, I'm the husband, Lordship. The wife side will appear, Lordship, after notice.
Sontu Roy and another.
Another is Bina Roy, it's mother of the husband, Lordship.
Simi Saha, this respondent number 2 is the wife.
Yes, Lordship.
We'll have to, she needs to come.
Yes, Lordship. Notice may be issued, Lordship.
This,
Lordship, also interim prayer is there to stay
To do
the
what?
proceeding of the PRC case, Lordship. BW is issued.
this is an application under section 528 of the BNSS for quashing the FIR dated 22/1/2022 in dispute PS case number, now which culminated in dispute PS case number 2483 of 2022, and also for quashing the charge sheet filed therein, and also to quash the proceedings before the before the learned court of the before the court of the learned judicial magistrate first class Kamrup Metro in PRC case number 120 of 2025. Full stop. The learned counsel for the petitioner has submitted that the petitioner number 1 and the opposite party number 2 have reached an amicable settlement regarding the matrimonial disputes existing between them. Full stop. He has further submitted that prior to reaching of such settlement, the aforesaid FIR had been lodged. Full stop. He therefore prays that unless the aforesaid FIR and the proceedings before the learned CJM is interfered with, the petition number 1 and 2 may be put to or disadvantage
Mhm.
when all matrimonial disputes have been settled between the petition number 1 and the respondent number 2, full stop. Issue notice, extra copies to Mr. Parashar, learned APP within a period of 1 week from today. Notice, steps for service of notice on the respondent number 2 to be taken by the speed post within a period of 7 working days from today. It has been submitted by the learned counsel for the petitioner that bailable warrants of arrest have been issued against the petitioner number 1 and 2,
One,
against both the petitioners in PRC case number 120 of 2025. Full stop. The learned counsel for the petitioner has therefore prayed that the efforts that the proceedings in the PRC case may be kept in advance during pendency of this petition. Full stop. In view of the statement made that the marital disputes between the petition number 1 and the respondent number 2 have been settled by mutual agreement, comma, this court, the proceedings in PRC 120 of 2025 shall remain in abeyance till the next date of listing. Full stop. The bailable warrants the bailable warrants issued need not be executed. Shall also remain in abeyance. Full stop. List this matter again on February 9th of February 2026, along with service report on the respondent number 2.
May I please, Your Lordship? Lordship, Dear Lordship, 4 petitioners are there, Lordship. Petitioner number 1, 2, and 3 are the accused person, and petitioner number 4 is the alleged victim. This is relating to child marriage, Lordship. And for quashing of the entire proceeding, FIR is at page number 23. This is a joint petition, Lordship. Petitioner number 2 and 4 are presently living as husband and wife.
Husband and wife.
Yes, Lordship.
Mr. Parashar, what to do?
Joint petition in case otherwise will notice, but here joint petition. Joint petition age is 17 years. At that time?
At the
17 years.
Yes.
Now, 2 things.
But
One,
marriage solemnized-
have you gone through the judgment that adolescent liberties, adolescent rights, in rear adolescent right, have you gone through?
Yeah. That is there
What
also.
we found was that the conviction remains, the sentence does not.
May 22 marriage solemnized.
Somewhere I have also read that quashing was not in good
Quash-
taste.
But-
Quashing of these type of offences against the children is not in good taste. Let the trial take place, let this conviction be there. Sentencing can be considered on the basis of the marital relationships. But if we keep quashing because the wife and the husband are coming together tomorrow, we do not know what is the situation of the wife. Under what circumstances she has to proceed with this marriage, just because she was forced into it. Because if we keep allowing these kind of things,
Yes. That
what happens is the entire POXO Act, where the child was required to be protected, that goes for a 6.
Well,
The authorities will keep tracking down and we'll keep quashing it. Should this be allowed like this? Where we simply stand up to say that, yes, now there is no possibility of a conviction. How can there be no possibility of a conviction? Admitted
When
position
it is not-
on affidavit here, it
not
was a minor.
not
The
this-
physical relationship took place when it was a minor. So the
Why
conviction has to be there.
Why Fox will not come?
The conviction has to come. Sentencing may be considered by the court saying that, okay, now that you are now living together, we are not asking you to carry out the sentence. But releasing them like this, and there have been instances, if I'm not wrong, where after the compensation is granted, petitions come up for
My lord.
quashing. These kind of things we are not appreciating at all.
Yes, yes.
This is
Yes,
something
yes,
which
that
where
also I
we
have
are
to do.
interfering
16,
in
17
the
years.
very intent of the POXO Act.
16, 17 years girl now become mother of child
Ah,
and.
if you,
investigation
when we were
is there
reading
for
the
sure.
judgment, the plight of that girl was being so elaborately described. A person who does not have anywhere to go has to stay with the husband.
Yes.
Now with the child, no other way but to
No
come to
other
the
way.
court and say that, okay, I forgive. That prunes other incidents.
My lord.
हो जाएगा बाद में later on you can get it quashed, whatever is happening, you get an anticipatory bail because of the young age, because the statements have been recorded, later on we'll get it quashed. High Court is there, चलेगा. High Court is not here for this. Yes, you want to have some objections or you want us to
No, no, my
follow the
objection-
procedure?
My objection is Shastra case always there, my lord, but only, my lord, in other cases, some people appeared and after notice passed. Now, because this case, as both they appeared, but my objection.
Do you
always-
think in view of that judgment of the Supreme
No.
Court, we have the authority to quash this?
No, no, my lord.
Yes, show us the judgment by which we can quash a POXO.
Lordship, there is
Proceeding.
several judgment, Lordship, of
Of?
the High Court, of this honorable court,
I am
Lordship.
showing of the Supreme Court.
The-
Show us something of the Supreme Court. Why don't you come up with that rights of adolescence case?
Yes,
Yes,
Lordship.
by
Where the
case-
Supreme Court has said, don't quash,
And-
don't
and-
touch.
And another aspect is that, Lordship,
Hmm.
here, Lordship, this is a case of child marriage, Lordship.
Yes,
first.
yes,
And POXO will definitely will come later.
yes.
Lordship. Whether the marriage was, Lordship, was a forced or not. This is a marriage, Lordship, where both the boy and girl were, one was 20 and 21-year-old and another 17 years. They fleed away from home.
Hmm.
At this stage, Lordship, may I pray for one thing, Lordship? Lordship may call for the case record.
Hmm.
The statement of the victim girl was recorded.
Hmm.
The statement, her statement was recorded before the police also.
Hmm.
So let it
Saying
be
that I
con-
had given all the consent, that I had consented to it.
they
Does
fleed
it
away.
matter below
It's a
18?
hard-
Yes, yes, Lordship, that's true.
Will it matter?
No, Lordship.
No, this has to stop.
And Lordship, so far as the judgment of the Honorable Apex Court,
Hmm.
Lordship, my submission would be, Lordship, may kindly fix this matter either on Friday or Monday.
Hmm.
I'll try to satisfy.
Have you gone through that judgment where the court says that do not interfere, you cannot set aside the conviction and the sentence?
No, Lordship, honestly.
There is a judgment of the Supreme Court, if I'm not wrong, in Ray, rights of adolescence.
I'll go through.
Supreme Court upheld the conviction. Supreme Court said that there is no business of the High Court to interfere in matters like this.
I'll go through
Theft,
that.
you interfere when both the parties are before you, you please do whatever you want to do. This thing you can do whatever you, POXO, you will not touch it.
Right, there is a judgment of the Honorable Supreme Court where it went from the Calcutta High Court to the Supreme Court. In that case, the court did not interfere with the sentence, but since the boy had already undergone the sentence, it was the period already undergone and he was.
The
he
period
was
already
tenant-free.
undergone was taken into account and it was recorded that because of the family relationship, we want to save the family now. We will not require them to undergo the further punishment.
And since it is a POXO. case,
Not this way.
I can give my learned friend.
That would be helpful. Monday,
Yes, I'll give it.
Friday.
Monday,
Let us
Lordship.
have it on Friday. Let
On
us
Monday.
put a stop to this thing.
My lord, I-
On Monday, Lordship.
They will proceed there. Conviction, if there is a sentencing, High
Yes,
Court,
yes, Lordship.
we don't interfere, Supreme Court, someone will interfere in the sentencing part.
This fact.
This will not be allowed. We will not be a party to this.
You're not. These facts will also be almost similar to that because there also the girl was 15 plus, boy was 20. The Supreme Court in that judgment has said, if the age difference is more, then
That-
the factors will be different. But if it is 15 plus 20, 16 and 20, this is the adolescence love stage. So that's why the Supreme Court said that period undergone, let him go. This may be not be cited as a precedent also. This is
Yes,
what has quoted.
yes, that we cannot take away the sentence. This is because the
that-
first time we are touching it.
That judgment cannot be set as a precedence to quash other cases.
No,
That is also there.
From what I remember, the Supreme Court has said, you will not quash.
My lord, it is right to privacy of adolescents.
I'll go through.
Criminal appeal number 1.
2024. 2024 August.
It is by Justice Abhay S. Oga and Justice.
August or May?
Yes, it is May 23, 2025. Your lordship is right.
May. List this matter at the request of the learned counsel for the petitioner. List this matter again on Friday,
Monday, lordship.
on Monday,
Monday.
to enable him to address this court as to whether this court would have the, whether the, no, to address this court on the law laid down by the apex court in case of in re right of adolescence versus so and so, so and so. Huh, might not be deemed. You have the citation somewhere? Huh? On Monday?
Yes, lordship.
This thing,
Yes, yes.
we cannot legalize these things, sir.
Lordship.
We,
Not placing all
day
these
day
as
before
well.
yesterday, we have passed orders. Yesterday, we have passed orders, yes. We are causing it. And then it struck our mind. What are we doing?
That's true, lordship.
Theft, robbery, cheating,
As per Gyan Singh,
business transactions, whatever you want to do. You settle it, we don't interfere. Good riddance.
for those Gyan Singh is there, lordship. Those things can be.
My learned friend can look into. It is at the time of taking away the girl from the lawful guardian. What was the intent? How they have done the cross, I don't know. Their intent is also an important factor which you wait in the mind of the court for the sentencing purpose. Not
There,
Yes.
there, not
There,
here. That
not-
is the whole issue, not here.
Not here,
Why should we be putting our foot in when everybody else is trying to,
not at this stage.
when the entire nation is trying to stop this business of child marriage? Why should we be a part of quashing proceedings, saying that, okay, the child has now said, okay, because she is now a major. Did she come when she was 18 days, 1 year? 18 years, 1 day?
No, lordship.
No. So just like a divorce proceeding, voidable marriage, you cannot come back after whatever number of years you want to. You have to take that decision within a certain period of time, whether I want to continue with the marriage or not.
That is.
Here,
yes.
it is when the husband is there, the mother-in-law is there, the father-in-law is there. Be a party to this. We'll all move a petition together. Nothing doing. Is it there?
As per section 3, lordship, it is 2 years, lordship, after attaining the age of majority.
So 18 plus 220 is the maximum time.
Yes.
When a person finds that, okay, I was not 18 and I don't want to continue a marriage. Here, does she have an option?
Yes, lordship. As per section 3, yes. She is having an option, lordship, once she attains the age of majority, lordship.
In child marriage?
Yes.
POXO?
Yes.
Even in POXO?
No POXO, lordship.
Proceedings are under POXO?
Yes.
We'll look into POXO. You're free in child marriage. You're not free in POXO.
Yes, sir.
POXO will know. POXO is something where we need to protect children.
Highly appraised.
Everybody now has to ask for a Aadhaar card, retain a certified copy of it before saying, before expressing the desires of, yes,
Highly appraised.
children need to be protected, nothing doing. Yes,
By this petition, we are challenging an order passed by the lower court, allowing the recalling of the witnesses.
allowing recalling of witnesses. Yes, what is wrong? What is wrong in recalling the witness?
Straight away come to the order path. It is page 48,
Page 48.
next page.
Huh? Accused is so and
Reading the
so.
second paragraph. The London Defense Council of the Citizen, number so and so, clearly states that the point only the defense side intend to further examine PW 1, 2, and 3, and 4, and request that the prayer may be allowed for just decision of the London Court. The London Council also submitted that the previous engaged council failed to take some material contradiction, even remain absent when the IO appeared for examination. But for that, but for all what he has done, the accused should not be made subject. Now we're coming to the last paragraph of that page. London Special PP had not raised any objection to the prayer so made, submitting that the prayer shall be allowed only with reasonable cost. How can in a POSCO case, you're allowing a victim who is a minor to come on the basis, only on the basis of a reasonable cost? Because the act specifically says, I'm reading the section 348 Matter.
Yes, what is
348.
Which is earlier 311 of
Oh.
the CRPC. Now it's 348 of the BNSS.
Three
348.
88,
In this, the tax court has already explained this matter. There are two parts in this. One is any court may. The word may is there, where the discretionary power is used by the court. On the second part, and the court shall summon, the cell is there. While exercising the discretionary power, it have to see, because this is mandatory, that if his evidence appear to be essential for the just decision of the court case. Now thing is that in all the statements, they are very constant statement of the victim, father, mother, and one. In case of IO, they did not appear for that. Only thing is that now the council has been changed. They have come with the statement of 113 has also been made by the king. Now they are coming with this application for recalling the witnesses. Now think the BNS 33 subsection 5, which specifically says that the victim cannot be called again and again. Now thing is that can be there is the effects of judgment also. The section 33(5) can be diluted only when she attained the age of 18. So now she is only 17 in her 11th standard. If you call her statement is also included with the petition. If you call her, you will see the mentality of the how she will be suffering mentally when she is called to the. Although the statement is very constant, whatever is made in the FIR, the statement of all the three are very constant. There is no difference in this. Only
So you do, the prosecution does not want, the prosecutors does not want to be recalled, is your case.
Even in section 33 of the POSCO, section 33(5).
The 3(5).
The special court shall ensure that the child is not called repeatedly to testify in the court.
33(5).
33(5).
Repeatedly to testify in the court, okay.
The statement is very constant. Statement is there
No.
with the petition.
The word repeatedly and shall not be called again are two different.
The essentiality of the evidence should be seen, because in their application at page 37, they have mentioned only one word. Improvement and omission. Now, the thing is that in Rajaram Prasad Yadav judgment, which was the state of Bihar, the apex court, they laid down some principles for
Recalling.
and that principles, his case does not fit in that principle. Because you have to specify in what basic point you are going to cross-examine. Because just telling that there is a omission, it cannot be.
You have an extra copy? You have a copy for the court now?
2013, 14 SCP.
I'll place all those judgments, my lord. The courts are very liberal so far, and I've given the justification for recalling of the witness.
Yes, which line you are seeing? Guidelines?
Paragraph, I think, I have taken it from the website. Paragraph 23. The case will
23
be-
years?
Laptop today. Must have yours. I'm just kidding. Yes, SHA today is not a bad example.
Page 473, para 17.
পঙ্কজ, মোৰ citation list খন দেচোন, তাতে paragraph কেইটা লিখি দিছিলো। মোৰ হাতে দি লিখা খন। মন যে হাতে দি লিখা আছে, look আছে। দি লিখা।
Yes.
I'm referring to G. The court must satisfy itself that it was in every respect essential to examine such a witness or to recall him for further examination in order to arrive at a just decision of court. But if you see the order, just because on the basis of a reasonable cause, you cannot call the victim, which has been suffering since the incident happened. Now, although the recalling can be done, they have not cross-examined the IO, that can be recalled. I have no objection regarding, I mean, not claiming also.
No, page 49, kindly see page 49. After going through the case record as well as petition, I am of the opinion that the points on which the defense intends to cross-examine, or more specifically, the contradictions which they intend to take, are material ones and will definitely have a bearing on the final outcome of the case. It is not because of the cost that the magistrate has said so.
No,
The magistrate has
But
formed an opinion.
The PP has not objected to anything. The IO has not, the cross-examination IO at that time, nobody appeared. Now the judgment of Ram Prasad Yadav, in that particular paragraph, in G, it specifically said that justify in every respect essential to examine such witnesses.
You want to recall only PW1?
No, what has happened, my lord? If your lordship looks into our application at page 37 of their petition, my lord. Your lordship, we have given elaborate, because nowadays, if you want to recall the witness, you have to specifically specify the reason for why that witnesses has to be recalled. And if your lordship looks at page number 37, 38, 39, 40, basically what has happened, the contradiction which they had said for the first time in the court, that was not put to the witness. And
Sir, what we would like to say is this. Some material evidence was not taken. Some material statements were not made. Some particular area of the statement was not clarified. You recall
Yes.
and you do it, we understand.
Yes, that's what we will.
Change of set of counsels, we want
no,
to
that is not the ground.
cross-examine, we want to
No.
place facts before them. It was not done by the earlier set of counsels.
No,
will
that is
not
not
be-
the ground.
That will
That is-
not be
Your
a
lordship
ground.
your lordship will see the ground number at page 38.
What we are
Yes,
anxious
yes,
is.
Yes.
what
It is
we are-
ultimately the concept of fair trial, and the accused should not be prejudiced.
When the fair trial was given to him,
Yes.
he failed to put certain questions
Contradiction,
before the,
especially contradiction.
before the evidence was closed.
Yes, ma'am.
He failed to put in some
Yes.
contradictions.
Yes.
Now,
That is, my lord, there are judgments of the honorable.
should
Supreme
we allow that to be done now?
Yes, my lord. And
Otherwise, we'll be allowing, we can allow that even after the appeal, we can allow that at
no,
any
no,
stage.
not after that.
Why
At
not?
any time, if you look, if
Why
you
not?
should
If
look
he
at-
says that I did not put this question.
No, 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 no.
And this question has been held against me and therefore now I should
No,
be
no,
allowed to put it.
no, my lord. The concept of 311 and the 348 of the BNS, with utmost respect, my lord, it says at any stage of the trial, it has to be before the pronouncement of the judgment, not after the pronouncement. Here
Okay.
it is before the pronouncement of the judgment, we can.
I failed to put this question to him before the evidence was closed.
No, evidence.
Can that be a ground?
No, my lord. Your lordship will kindly see first the why I want to recall the witness at page 38. Page 37.
These contradictions were not
Yes.
put to them.
Yes, now your
That was
lordship
the
will
fault
see
of the
page.
defense.
Huh?
That was the fault of the defense.
No, my lord, there are judgments of the Honorable Supreme Court. Now what has happened? Normally in the trial court, there was one judgment of the Honorable Supreme Court. I'll come to that. He has not concluded that that's why I was not interfering him.
Anything more,
Stay.
sir? You need to, you want to press anything more? in
Let
this?
him continue.
Only, it should be, they have mentioned only some contradiction, but they will have to satisfy the court, particular on which point they are going to.
That they have given, they will not go beyond 37 and
That's not
38.
First time in the court.
37, page 37, 38, 39.
Tekuna, they are going to fill it, because the statement under 131 CRPC.
Ah,
already been done.
yes.
Especially in POSCO case, such cannot be allowed recalling, because the victim is there mentally, it's just been harassed like anything.
Yes.
The thing is that, because the POSCO Act also 35(5) also says like that. She is only.
How many witnesses left?
Well, three witnesses, they
No,
have
no,
not
all the
enclosed the
witnesses
last
completed.
order.
Huh?
Last order.
All the witnesses have been completed.
4 witnesses are there.
IO, they did not cross-examine the IO.
Well, 4 witnesses are there. Mother, father, and the daughter. In terms of this order, the court directed us to deposit the cost of 10,000 rupees. It is fixed on Wednesday next for re-examination of this 3 witness. And I undertake before this honorable court that on the next day or on the last day also we went last week. They said that we are filing a petition before the High Court, although there is no statement. Then I said the court that let the High Court look into it. We'll go and appear and we'll try to satisfy the court why this re-examination required. It is now fixed on 17. And I assured this honorable court that I will personally re-examine all these 3 witnesses on that particular day and finish it. And I have given the reason, it is only for putting the contradiction. Because if I don't put the contradiction, the accused will be prejudiced. Because your lordship will know that contradiction has to be put in terms of section 145 of the earlier Indian Evidence Act, which is perimeter with the new BSS. There are judgments of the Honorable Supreme Court which said that if for some reason, for the fault of the counsel, contradiction cannot be put, even the trial court can't sit as a mute spectator. The trial court has to test the junior counsel or the counsel who is appeared. That counsel, look, if you want to put this contradiction, you have to put it in the quote, unquote paragraph and put it to the witness. And when the IO comes, you have to confirm them. That's the procedure, how the contradiction has to be proved. Because in India, your lordship knows that nowadays, because the cross-examination, now nobody wants to go and do cross-examination in the trial court. That's why it is said that it is a dying art. And that's why the Honorable Supreme Court has said, even to the question the trial court, that you will not sit as a mute spectator. You under 165 of the earlier Evidence Act, you have to take part. And we have given the justification. This has also in terms of the Honorable
The
Supreme Court.
justification of what could have been asked before the evidence was closed.
No, no, if your lordship looks into the language of this section again.
Yes.
This has been explained. I'll come to the judgment.
Please.
Your lordship will see at page 36, I have quote the judgment. Sorry, the section 348 BNSS, page 36.
I'm reading the book itself, yes.
Yes. Power to summon material witness or examine person present. Now, any court may at any stage of any inquiry, your lordship will see at any stage of inquiry trial. Here we are concerned with trial or other proceeding under this Sanhita. Summon any witness as a person as a witness or examine person in attendance, though not summoned as a witness or recall, and re-examine any such person. Why this is required? Because if his evidence appears to be essential to the just cause of the case. That's why, my lord, your lordship will see now the interpretation of section 311 by the Honorable Supreme Court, my lord. It was judgment say.
Can this be stretched to the extent of trying to fill
My lord,
the
it's
gaps?
courts are very liberal now, and so far I'll place all the judgment and the interpretation of the Honorable Supreme Court. There are even judgment of the Honorable Supreme Court which said that if for some reason the contradiction can't be put to the witness, and if there is an application for recall of that witness, the contradiction has to be allowed. And so far that POXO section is concerned, it is only means again and again, repeated means again and again, after and after. So that is not there. And we have
Cannot say that she cannot be called back even once.
Yes.
Maybe a
we
necessary.
are giving an undertaking before this honorable court that on next Wednesday we'll examine 3 witnesses.
Whether you are allowed to.
Yes,
recall,
then we'll, yes, madam. Let me place all the judgments of this honorable Supreme
Because,
Court.
because something could not be done by.
No, madam. That's
At that point of time,
No,
it
no,
was
no.
not done.
No, madam.
And now, okay, now I'll be trapped and I need to go
No,
back and do that.
No, that
That
can
is-
be done.
that is-
I'll scroll from the honorable judgment of the Supreme Court on what point the recall of this witnesses has been done and why the trial court is right in passing this order for recalling of this witness, madam.
You
May I
have
place
the-
all those judgments, madam?
Please.
Yes. Your lordship has the SCC online or no?
Should we have it?
Should we not? 2022 today.
এইটোতো আহিব পাৰিব লাগে আচলতে, I don't know.
There's judgment in there.
হা?
কোনটো?
section?
এনেকুৱা কোৰ্টৰ কাৰণে আছে ন?
আপোনালোকৰ কম্পিউটাৰ সেকশন শুই আছে। কি আপডেট কৰিব লাগে মই বুজা নাই। আপডেটটো কি কৰিব লাগে? এই নকৰিব।
My lord, these are the judgments. I have given the entire history of the 311 sections, my lord. The first judgment I will be referring is Ramchandra Rao versus State of Karnataka. It will be the paragraph 20, and it is paragraph 26 to 29.
Let us do it this way,
My lord.
Mr. Kumar.
My lord, your lordship.
I'll have to log in and this and that. This will take some time. Other cases will be waiting in the meantime.
My lord, may I pray that?
We have it at
two?
I
Get a
we
printout
have it
of all
at two. Either you take a printout or
I'll
the
take-
SCC log it.
I'll not trouble. I'll take out a printout.
I
of all-
can,
Yes, I will
just
print out.
because
Yes,
it is logged in on my other laptop and not on this one.
yes.
So I'll
And
have
my-
to again remember the password, come back to this.
Oh, no, my lord, nowadays, High Court is giving us all free internet for this laptop.
Not about that. The SCC online
Oh.
that from the other computer, I have to come back to this.
Your
computer.
lordship, if this is a iPad one, then I can airdrop also. I can airdrop all the citations.
Not so technical. Add two.
We
We have the list.
Ah.
We'll have the,
all the citations I will give. And,
at two, we'll take this up.
yes,
Let others not wait.
yes, yes.
Till we are-
Before vacation, my lord, nobody wants to, we also don't want to trouble my other councils.
It have to দিব, হ্যাঁ? বারোটা পাইছো যে এতিয়া 12টা বাজিলে দেখলাম। Yes. Yes, sir.
Timing, my lord, ASL for Guru will ASL, my lord.
Huh?
Timing.
দিয়ক, 14 দিয়ক। 14.
40.
Timing.
Excuse your lordship.
Yes.
This is for quashing of the proceeding of the PRC case number 41 of 2024, which was, my lord, under section 265, 385, 34 IPC, my lord. Lordship, total 5 accused, my lord. Allegation is that, my lord, accused number 1, my lord, kidnapped the victim, the daughter of the, my lord, informant, my lord. But in fact, there is no case of kidnapping, my lord, or extortion like this, my lord. Petitioner number 1 had a love affairs with the victim, my lord. And thereafter, they also got married also. I have annexed one document, my lord,
Hmm.
page 34,
Hmm.
my lord, by way of Kabinnama, my lord.
Huh?
Kabin. Lordship will find page 33.
Huh.
But later on, my lord, this girl, my lord, not with me, my lord, but from the record as well as my lord charge sheet and the statement which was recorded while granting bail, my lord, it is stated that, my lord, some allegation against the petitioner number 1, my lord. So all other accused persons are implicated, my lord, and learned, my lord, trial court while taking cognizance, my lord, that part is not taken into consideration, my lord. So I am coming before this honorable for watching of.
Why don't you prove everything there? Why don't you prove everything there?
But my lord, so far, my lord, cognizance order, lordship may kindly see,
Huh?
there is,
Suggest frame, charge frame question again.
When can we interfere? When there is,
Charges were not yet framed.
but
At the time of framing of charge, they can raise this issue.
page 21, my lord,
while framing of charges,
next date is for framing of charge.
then why don't you try there not to have charges framed against you, nothing on record against you? Tell it to the trial court.
But while taking cognizance, my lord, learned court had,
This is photostat, this high court will become otherwise a photostat court.
my lord.
What grounds can be raised there? Photostat copy raised here, then we are looking into the entire affair. They are not.
But at the
Can
time
that
of
be
taking
done?
cognizance, my
Huh?
lord,
Huh?
learned, at the time of taking cognizance, learned for trial court, I had to see, my lord.
The
those
learned
cases.
trial court has to see whether
There is a
the
prima facie case. also.
case, so the prima facie case is there.
But,
Maybe not against you. Is it not? So a case is there which needs to be tried. Court has said, okay, call all these people, we will see whom to charge. Then you will go and say that, okay, nothing against me, no charge. Court will say, okay, no charge. Why here? If we say, to interfere with the cognizance taken, show us that there was no case for the trial court to take it up. It has to go stage wise.
From the cognizance order, my lord.
It has to go stage wise.
Say that, my lord, perusal of the CD.
This is the first part of the sealing. Whether the court should look into it or not. That is cognizance.
Yes, sir.
Now, against whom to look into is the charge framing.
That is correct.
Tell this to the court.
Regarding.
They still frame a charge against you, come back to us. That with nothing on record there, he's trying to frame a charge against me. He's including me in the charge. We'll look into it. But unless the trial court has the opportunity to at least hear the grievance,
That is correct, my lord, but so far.
supervisory power,
Cognizance order, my lord.
is it not supervisory power? What you are asking us to exercise?
No, inherent power.
Huh?
This is inherited power.
Is it not? So we will take it up from him. It is just like telling that the ministry should not do it, contractor should directly do it. We will not do it. Tell him first that looks are nothing against me, so no charges should be framed. He says no. Without your name also, we will continue with it. Come back to us. Tell it to him first. When is the next date?
It's, my lord, next date is 20. 1 minute, lord.
The request
My
of the
lord,
learned.
20, that is 30/12/2025.
We'll fix it in the month of January. Move the application there. Whether charges are framed against you or not, if charges are framed, file an additional affidavit, we'll take up the matter. If charges are not framed, come back and withdraw this. At the request of the learned counsel for the petitioner, list this matter again on 29th of January 2026. Since the matter, since it has been submitted that the matter is again listed on 30th of December 2025, full stop, petitioner will be at liberty to take appropriate steps to convince the trial court not to frame charges against the petitioner hearing.
Madam, the fixed 29 January. When it is
29
29.
February, yes. It is made clear that there is no that the proceedings of the learned trial court would not be influenced by the pendency of this petition and any prayer made by the petitioner before the learned court shall be considered on its own merits. Is it not? Anybody put up for trial, charges are not always framed. You can convince that court. Right there first. Yes.
If petitioner is willing to appear, but due to strength of NBWA, he is in apprehension that he may be remanded to judicial custody.
Why did he not have the urge when BWA was
No, he has lost his contact with the council
counsel?
at that time. In fact, it is true that he is suffering from some ailment. And the subsequent dates, he has no knowledge. Only, however, he throw a petition writer, tried to test out the position of the case. Thereafter, he only well known about the fact of pendency of warrant last 3 occasions. But he is
What kind of disease?
I have not annexed, though I have not annexed. In fact, it was to the suffering from some.
On the execution of BWA, you had moved a petition citing grounds for absence. Page 25.
Page 25.
Thereafter NBW.
Thereafter NBWA, because we have not annexed any medical certificate.
Huh.
Because on that day, I lost contact with that council, 28/5, I have already lost contact with the council. At that, only 10/3/2025, when BW issued, on that day, he has contact with.
On 10/3?
10/3/2020, page number 23.
Yes, that day also you are absent.
Absent, yes, I have of course absent.
You have never appeared before the court.
No, not till date. I want to appear now, because
What is the allegation against you?
it is an NIAC case proceeding. NIAC proceeding. Someone
He
proceeding.
undertakes to appear, yes. Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard the learned APP, full stop. The grievance raised in the present petition is against the non-bailable warrants of arrest issued against the petitioner for his continued absence before the learned trial court, full stop. The learned counsel for the petitioner has submitted that the petitioner is ready to face trial given an opportunity to do so, but the existence of the non-bailable warrant of arrest puts an apprehension in the mind of the petitioner that he would be arrested on appearance, full stop. Heard Mr. K.K. Parashar, learned APP, who has APP, full stop. In the facts and circumstance of this case, this court directs that the non-bailable warrants issued against the petitioner on
28/5/2020.
subsequent to the order dated 28/5/2025 and other subsequent dates be kept in abeyance till when will you appear?
19/12 is the next date.
Till 2012/2025, allowing the petitioner to enter appearance on 19/12/2025, full stop. On his appearance, the petitioner would be at liberty to file an appropriate application before the learned trial court to be allowed to remain on bail, which application will be considered by the learned trial court on its own merits and in the facts and circumstances of the proceedings, full stop. on the failure of the petitioner to appear before the learned trial court on 19/12/2025, the interim protection granted by this court shall remain revoked automatically without further reference, full stop. Criminal petition disposed of. Shall we consider the petition on for bail to on its own merits on such terms and conditions as may be imposed upon the petitioner?
Addition, item 16.
Yes, Mr. Das.
Lordship, in this matter, we have sought for some accommodation from your lordship
Ah.
in the morning. Sir, as Borali is out of station.
Okay.
That's always
But this
lordship,
is of
I-
2022.
Lordship, there is an IA which we had filed for suspension of the sentence and for releasing the petitioner on bail. So,
What was the allegation?
Lordship, the allegation was that the petitioner had indulged in an act of rape and he was convicted for a period of 10 years. Now, the issue here is that, Lordship, the defense story was that there was a love affair between the petitioner and the victim. This aspect was not taken into consideration by the trial. Trial court proceeded on the assumption that assuming there is a love affair, but no means no. But that no means no has to be proved by the medical report. The doctor herein has given a categorical statement, his evidence, that there was no sexual activity during the past 7 days.
Huh?
That Lordship will turn, if your Lordship turns to the evidence of the doctor at page 24 of the IA. Lordship will see
Statutory appeal, Lordship.
it's a statutory appeal, Lordship, the appeal has been admitted. Otherwise, the records have been called for. And
No, then what do? We pick a date?
because Lordship, he has
Pick
been
a
in
date, we'll take
prison
up the
for last
appeal
3.5
for
years.
disposal. Huh?
He's already spent 3.5 years now.
Exactly.
That's why, Lordship, we have treated this application for suspension so that till the matter is taken up, because in the objection which is filed by the PP, they have also, by the state, they have not taken the ground that he had violated any condition of the bail when he was on trial. The Supreme Court is categorical to that extent that if the person has not violated any terms and conditions or he has not indulged in any offense while he was in bail during the trial, then he should be given the benefit because the appeal takes time to hear because there are a number of pendency of cases in the High Court. It takes time.
I couldn't go to the LCL, Lordship.
Huh?
I couldn't go to TCL, Lordship.
That is what we'll give you that time. When do we have the matter?
After vacation.
If you can pick a date, what we will observe in today's order is that he has asked for the leave to go through the TCR to.
Lordship, then your Lordship has to take the final, the entire appeal for hearing on a final date.
Exactly, and
Lordship,
we will also provide that if in case the matter cannot be taken up on the next date, your prayer for interim bail and suspension will be considered.
Can I just give the date to the court master in a few minutes? This is Mr. Murali whenever he's.
Yeah, but you take your, you give the date. Yes,
On January 7, 8.
7, 8, whatever you want.
Lordship, let me just get.
Earlier the better, yes. You tell the court master.
Yes.
अपना कोई
So
होगा
Lordship,
ना?
this matter will come up for hearing.
It will come up for consideration of the appeal on 7th or 8th.
Or for final hearing
Huh?
of the appeal.
Yes.
Lordship,
And in case it cannot be taken up, we'll consider the
Lordship,
prayer for
that must
bail.
be recorded.
How will, yes, at the consent of the, Mr. So-and-so, APP has
Finally.
submitted that he may be granted a short accommodation to go through the trial court records to assist this court to adjudicate the appeal, full stop. At his request, let this matter be listed again on 7/8, 7/8 January 2026, on which day an attempt would be made to take up the criminal appeal itself for disposal. Full stop. It is provided that in case the criminal appeal is not taken up for disposal, an attempt would be made to consider the prayers made in the IA criminal number
1146 of 2025.
okay, for bail and interim suspension of the sentence.
Item 18.
Huh? Yes, yes.
An appeal, Lordship,
Ah,
conviction against the POXO case, Lordship,
Hmm.
POXO Act. Lordship, judgment and order dated 24/10/2025 passed by the learned special judge POXO Golaghat. And convicting the accused for appellant, Lordship, under section 10 of the POXO Act, and sentenced to undergo rigorous imprisonment of 6 months and of fine rupees 10,000 in default of undergo simple imprisonment of another 1 month, Lordship. Lordship,
You've seen the TCR?
18 में है ऐसा नहीं 18 से ऐसा नहीं
Judgment of 2020, how much, what is the sentence?
sentence, so rigorous
18
imprisonment,
today it is
6 months.
today it has come for
Arrive
admission.
for 6 months.
So
Ah.
may admit it, Lordship, in the meantime this year has not come, Lordship.
Eh?
This year not come.
TCR has not come?
It is for admission only today it is first day.
Today is the first day.
First day, Lordship. Today appeal, Lordship.
Heard Mr. So-and-so learned counsel appealing for the
Notice will go.
petitioner, also heard Mr. So-and-so learned APP. This appeal is against the judgment and order dated 24/10/2025 passed by the Special Judge POXO Golaghat, full stop. Admit the appeal, full stop. Call for the trial court records list again on a list again in the month of February.
Notice will go, Lordship, POXO method. POXO method.
List again in the month of February 2026. Petitioner to take steps for notice upon the respondent number 2 as per the prevalent notification within a period of 1 week from today. Call for the TCR to decide, no? Yes.
There is also an IA, Lordship. IA for he is on jail, Lordship.
When they file a bail application for, when the trial is going on, even at that point of time, we have to have the
No, Lordship.
respondent before us before we can consider the bail. Is it not?
Notice.
We'll keep it, we'll keep it a little earlier.
Notice
To
maybe.
23rd of January কৰি দিয়ক 23rd of January কৰিব হা আৰু notice on the IA কৰিব এখন IA আছে ন লগত IA খনতো heard Mr. So-and-so. This is an application praying for keeping suspension of this sentence imposed by judgment and order dated so-and-so in POXO case number so-and-so. Issue notice to the respondent number 2. Extra copies to the learned APP. 23rd of January. List again on 23rd of January.
All right.
Yes.
May it please your lordship.
Ah.
Lordship, this case is with regards to the Zimma of a vehicle, car, which was allegedly used in narcotic substances transportation.
Which was used in?
Drugs case, your lordship.
Ah.
However, your lordship, the case is as such that one person was apprehended with certain amount of drugs. He said that I, the owner of the vehicle, is also involved. My vehicle is parked in my garage. Police comes to my garage. I am not at my house. Then they open the car and they said 3 number of boxes were recovered, from which only 34 grams was recovered. And it is not such that there was some secret compartment in the vehicle, so and so. From which part of the vehicle they took out the soap box is also not mentioned in the seizure list or the charge sheet, your lordship. They found it, most probably, let's say they found it in the seat or in any portion of my car, which is not a secret cavity also, your lordship. Thereafter, the Zimma, it has been 7 months, 25 days. The Zimma of the car has been rejected twice by the district court, Sessions Court, your lordship.
Yeah, in
And
this case,
against
Lordship,
their order-
earlier, in this case, earlier, a police report was called for. Lordship, I will, I may allow to check whether it has come or not also in our office.
At 2.
At 2, Lordship.
At 2.
At 2.
Much
At 2 at 2.
Lordship, when this method, the engaged counsel is on legs, may it be taken up after something.
Apology.
49.
Three.
No, supplement.
Living item, I think today.
স্ক্রোল দিয়ক না রেসপন্ডেন্ট না যাক লাগে কি নেই
Today also they are absent, but I telephoned also. She was to come.
she has informed you that she would not come today.
No, she is in the court, or somewhere in some.
Oh.
Yes.
May please ask. And Paul is coming, and that is coming down. Who? And that's junior government.
No, he in NSI.
We required Miss Arbora to be,
I think she also in court number 5 laws.
or they're in court number 5.
I have met her.
After some time, sir?
Or if two madam, directly.
Two. At 2, tell her.
I'll.
If two madam.
at 2 রাখো at 2 থাকিব
It will be free.
Please, your lordship. Lord,
This one?
maybe take at 2, lordship.
Why?
Lordship, we have taken consent of other party, Mr. SCKL, lordship.
Huh?
Taken consent of Mr. SCKL, lordship.
The only reference we find here is bail application rejected. There's an earlier order for some co-accused, I think, co-ed 2. After 2 heavy board over the. Which record?
1053.
Due to your non-appearance,
Fire, I was running like anything.
we have kept it at 2 o'clock. Yes, Mr. Sharma, can we take it up now? No, it was 53 to Mati. I said division party. Deedখন পতক আছে।
Item 53.
Yes, madam. Any finalization of that instruction that we had asked for?
This very, our, award is final.
Award is?
That interim order, so-called interim order is also final. Because they
That
have-
is a final order.
That is the final, because they have annexed that in the report of by NSI. Roshangal is annexer 1 page 10 of the, my lord, ABDBT.
Yes, sir, Mr. Das, what do you have?
At 2, my lord.
This is- After this, it will be after 2 years.
No, at 2 months. Part of the matter.
Yes, at 2 years. At 2.
22.
22. Yes, sir.
23 application, my lord.
Huh?
I'm booked under POCSO 6 of POCSO Act, my lord.
Eh?
DNA report was called for, my lord.
DNA just now received. Lordship may fix it on day after.
You are for the?
Yes, for this one.
Respondent.
Can it be on
Some-
Monday, my lord?
Lordship.
Some DNA report has been called.
I have just received now, Lordship.
Okay. Your case is that
My lord.
Not your child,
Not my child.
not your
I've said
child,
it in paragraph 8, my lord, or page
Eh?
6, my lord.
not your child. How does it matter? We are talking of one incident, may or may not be your child,
My lord.
maybe a previous child, whether you are involved or not at all.
My lord. This my DNA report is received, my lord. Can be on Monday or Tuesday, my lord.
Monday?
Monday, my lord.
Actually, I have not gone through lordship because of, I think that DNA report.
He's praying for Monday.
Not-
It's a bail application, Monday.
Monday.
The learned APP has submitted that they have received the test report recently, today. And therefore, prays that the matter may be taken up on Monday, Tuesday, Sailak, Kundinakan dibo pare. Monday this is 16.
16.
WhatsApp.
24, here.
Lordship. Lordship, this petition is behind number since 5/25, Lordship. Yes, on today, 32 days, they behind the bar.
Scan copy actually. Scan copy call to substitute this.
This year, on last occasion, this year.
TCR was called for it, but in the causeless lordship, it was not, it is not shown as a TCR received. As a-
The last office note is of 6/12. Of 6/12 saying scan copy of CD and CS has not been received.
Scan copy of CS.
CD and CS. 14/11 there was an order. Just a minute. Case diary and charge sheet of Matia police case number. That is what was called for by this court on 14/10. What should we call for? The TCR,
TCR.
since it is charge sheeted.
Charge sheeted.
Uh, The office note dated 6/12/2025 reflects that the scan copy of the CD and CS has not been received. Full stop. Office note dated 1/12/2025 reflects that requisition for scanned TCR comprising of case diary and charge sheet had been sent to the Civil Judge Junior Division number 2 JMFC Gwalpara, Assam by memo dated 1/12/2025. Matter was listed today, and this bail application was directed to be listed today, full stop. Registry to issue a reminder and list this matter again on
Before vacation, what's it?
Before vacation, any date, Lordship?
before vacation first matter karone jagai na thakibo dekun.
Already full.
Immediately on reopening.
Reopening the
5th, 5th, 6th, huh? 19th of December 2026, full stop. Yes,
1912.
NDPS. What was the amount recovered?
Bottles, Lordship. Comment.
125.
Matter may be taken after some time.
So TCR received services also completed. So any person was representing respondent number 2 is or not, otherwise amicus may be appointed.
Today we'll appoint an amicus. And Services completed. Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard Mr. D.P. Goswami, learned counsel, learned APP, full stop, who has submitted, who has submitted that the service on the respondent number 2 is complete as per his instruction, full stop. None appears for the respondent number 2 today, full stop. In that view of the matter, so-and-so is appeared, is appointed as the amicus curiae. Srimati Roshanara Chaudhary is appointed as the amicus curiae, full stop. Petitioner to serve to serve copies of the petition on the learned amicus curiae. List this matter again on
Reopening 6th of January.
6th of January.
Of last.
26.
Or TCR has been received.
Please, the lordship, madam.
It will be here. TCR no, no, no. TCR has been received. Yes, sir.
My lord, in this case, my lord, the service is complete, my lord.
Hmm.
And POCSO section 4, my lord.
Hmm.
But prima facie, my lord, the FIR, my lord, kindly for a moment, though there may be the amicus curiae may be appointed, my lord, but the page number 8 for a moment, my lord, page number 8, my lord, for a moment, my lord, the FIR. The false and fabricated FIR, my lord, that with regard, I beg to state that Ankur Rai, the petitioner, used to come with Maniknagar near village so-and-so. He was found near home at least 2 and 3 months. I was sleeping. That is the brother of the, my lord, victim. At 7 a.m. on 21/1/25, the January, my lord, in the morning, that accused Ankur Rai came to near my home and asked for water to my sister. Mamoni, 14 years old, my lord. When my sister went to give him water, he pressed her mouth with hand and took her away at Eltokar. It is kidnapped, my lord. He started to rape her forcefully from that day. And whenever the accused
No, please,
was accused
we'd like to see the
further
Assamese version.
accused tried to commit so and so.
Let us see the Assamese version.
So, my lord, 2/25, he lost the FIR after about 1 month, my lord. He was present in the morning in his house, and then even, my lord, he has lost the FIR after 1 month, my lord. And my lord, after 1 month, when the my lord victim card returned, then he lost the FIR, my lord. Version is, my lord, page number 12, my lord. It is in Bengali, my lord. Married, my lord.
Yes, can you?
Married, my lord. My lord, 12. বিনীত নিবেদন এই যে বিবাদী অঙ্কুর রায় প্রায় 2-3
Just a minute. POCSO matter বিলাক আহিলে sound টো অলপমান mute কৰি দিব. Victimৰ নাম আহে, কিবা নাম আহে, these are not to be made public. কৈ দিছে ন? This is to be muted. Yes.
married. প্রায় 2-3 মাস হইতে আমাদের গ্রামের নিকটবর্তী
All motion days matter which has been declared today and the next week to keep everything for January.
This exceptional case may be taken out. The exceptional case from the FIR, my lord, my prayer, my lord, before.
The order dated 3/12/2025 has recorded that the service on the respondent number 2 was completed on 2/12/2025. And therefore this matter was required to be listed today. Full stop. None appears for the respondent number 2 today also, full stop, in that view of the matter. The Ornab Phukon, the council is appointed as the amicus. The council for the petitioner shall serve extra copies on the amicus. List this matter again on the 6th of January,
My lord,
2026.
my lord, he about 5 months, he is, my lord, behind the bar, my lord, for the last 5 months, my lord. And the prima facie, the FIR is the false, my lord.
He was arrested when?
Oh, my lord, on 13/7, my lord, 5 months ago.
When did you come to this court?
My lord, after, my lord, rejection of the sessions court bail, my lord.
Huh?
After rejection.
When was it rejected?
My lord, rejection order, my lord, I had annexed, my lord. 20 September, my lord.
24/9/20.
24/9. Then I have.
4/9. And when did you approach this court?
My lord, there is
First
some
date
financial-
2011
Of November, you let 1 month go in between,
Financial.
wait for 20 days.
Financial hardship, my lord.
Huh?
Any date before before vacation, my lord. Financial hardship, he could not, my lord, appear. Any date, your lord, before the vacation, my lord, 21 or 22, my lord.
Huh?
21 or 22, my lord.
21st. Yes, he wants 21st of December. Should we fix it 21st of December?
No, sorry, my lord, sorry. Or 26 list, my lord. Sorry,
Eh?
on 19, my lord.
19 December.
On 19, my lord.
I don't know. Huh? উপায়তো নাই। 19th. Okay, 19th. we'll
Of
do
like-
it on 19th.
27.
27 also after some time, learned APP, PS law has gone through the year also. So he is on another court also after some time.
After some time. Yeah. After some time, please. Law. APP law কৰাইব।
28.
Yes, sir.
Likely lordships. So this is regular bill application lordships. It is on the behind of our last 14 months lordships. Last statement of lordships. Page 15 is the affair lordships.
Page?
15 lordships.
What is 10?
Lordship. This Barney Brown lordships. Page 15. May I read the affair lordship?
Huh? What about respondent?
He has appearing.
Objections to the bid? Huh?
Victim and informant already examined lordships.
Fully implicated and medical report also said that redness, bleeding and swelling in the private parts. And,
Uh,
a
14
evidence-
months, my lord, already 5 witnesses already examined lordship.
Eh?
Already 5 witnesses already
14
examined.
months.
My lord,
Minimum is how much?
lordship.
Minimum is how much? Whether penetrative or not, what is the minimum? 14 months is nothing.
6 years minor child lordship.
Huh?
6 years of minor child.
No, I will face the trial lordships. Already, I will face the trial already 14 months lordship.
After 4-9, any witnesses?
No lordships, nothing.
Hmm?
After already 3 months gone lordship, no test has been examined lordships.
Yeah, it was 4-9.
Yes, last examined on 4-9 lordships.
Hmm?
Last witness examined lordships on 4-9 lordships.
Who have been examined?
But
informant.
Not that, some witnesses were
No,
examined.
there are total 11.
11.
11. Who remain?
Well, medical officer, thereafter, police officer, IU lordships. And other 3%, 4% lordships.
Expedite the trial. Expedite the trial. Yes, heard Mr. M. Hawk, learned counsel appearing for the petitioner. This petition, Mr. So-and-so, Mr. D.P. Goswami appears for the, as the learned APP, and Mr. D. Medi, huh? K. Thakur has appeared for the respondent number 2. The petitioner in this case had been arrested on 26/10/2024 in connection with special POXO case number 19 of 2025 under section 65(2) of the BNS Act, read with section 6 of the POXO Act arising out of Dhula PS case number 152 of 2024 full stop. The FIR indicated that the mother of the 6-year-old victim had raised allegations against the petitioner herein, that the petitioner herein had abused the victim child after the child had a quarrel with her, with the son of the accused, full stop. The learned counsel for the petitioner submits that already the with evidence of the child and the informant have been taken. Full stop. There are a total number of 11 prosecution witnesses, out of which
5 Lordship.
5 have
Let them-
already been examined. Full stop. The learned counsel for the petitioner has submitted that when the vital witnesses have been examined, comma, there is no requirement of the petitioner to continue behind bars, as there is no chance of influencing or hampering and tampering with the evidence of the either the victim or the informant, full stop. Learned APP and the learned counsel appearing for the respondent number 2 have submitted that 5 witnesses still remain, 6 witnesses still remain to be examined, out of which only 3 are official witnesses, and release of the petitioner at this point of time may allow him to influence the other witnesses whose examination is yet to be conducted. Full stop. We have considered the learned, the submissions made by the learned counsels for the appearing for the parties. Full stop. We have also gone through the order dated. What was that order you are referring to?
4/9/2023.
Order dated 4/9/2025 passed by the learned trial court in special POCSO case number 19 of 2025. Full stop. The TCR call for has also been received. Full stop. In the facts and circumstances of the case and keeping in view the manner in which the trial is proceeding, comma, we do not deem it fit to allow the petitioner the privilege of bail at this point of time, full stop. Accordingly, this bail petition is rejected, full stop. The petitioner shall, however, be at liberty to approach this court again after the evidence of the prosecution is closed. Take a chance then.
It's a simple matter, my lord. In FR is submitted before the learned court.
Ah.
I was not given any opportunity to file objection.
Ah.
But this is the second time. The first time the final report was submitted,
Ah.
where I was given the opportunity to file objection, and the learned court, my lord, sent it for further investigation. Then when the investigation was not developed, my lord, then I filed a petition before the learned court seeking the status report of the investigation.
Mm.
Here on that date, the investigating officer comes up with a final report. The learned court closed the matter without giving the petitioner any opportunity to file objection against the final report.
Eto ahise niki trial court record to ahise? Huh? Case records of GR case number 17. Cause list of 9, no?
It is not shown in the cause list, Lordship.
Well, the last order, if I may take your lordship to page 27.
Huh?
Page 27.
Of the petition?
Of the petition.
To do what? Unless the records are here before us.
Our record will contain only this order, Malad. Nothing has initiated in the learned trial court. Only
Yes, Mr. Goswami.
Lordship.
Kindly see this. No, the petition number 2695 was disposed of.
Yes, my lord.
Where is the order accepting the final report?
But this is the order, the petition number disposed of. No further order is made, my lord. Like, my lord, in the other round of litigation, page 18, when the first order was passed, when the investigating officer comes up with the final report, here there is a categorical finding by the learned court that there is a further scope for investigation.
Was it on an application filed by you seeking status? The earlier order was passed on an application filed by you asking for the status of the investigation. No.
No, my lord.
It was an objection filed by you on the final report submitted by the IO.
But opportunity was given.
You were called for.
Yes,
Here
here.
you have not been called
No,
for the
no opportunity was
opportunity.
given.
We'll list this case again in the month of February. In the meantime, make an application before the particular court that on the FR, what steps have been taken. I have my objections. These are my objections. Pass an order on this petition. He'll give some order, then we'll see. This is a very unsure situation. Since you say that this is the last order, when this matter comes, then we'll have to ask the court, the trial court, yes, what did you do? Have you closed it? Have you not closed it? Move an application, come back, saying that it has been closed or further investigation has taken place. Something will happen there.
You see, my lord, this order was passed in the month of August 2024. It is 25, my lord, more than 1 year.
You have not been called. Make a prayer there. Even if it is closed, once your petition is made there, they have to pass some order on it, saying that we have already closed it, or yes, we are taking it up again.
Petitioner is conducting his case through legal aid. And
This is where?
here, Kamrup.
What is this page 20? Page 20? Page 19?
Page 19 is a complaint, I think.
This was the complaint lodged by, this is the complaint when the police was not accepting the FIR.
He is a
If I-
captain what?
Yes.
Captain of what?
It's a commercial pilot. He was undergoing a training and now he used a prefix captain. I told him that not to use it, but he was
Alright.
insisting.
That we are not concerned with. It can be Shri and so and so. So there is no difficulty.
This is the
Now, even if it
156
is,
petition.
this is in which court? Metro here, one
yes.
application. Metro here, one application. Good for evening walk also from here to there.
Yes.
If we keep waiting for this report,
I will instruct my client.
it will not happen. Nothing will process much. If you want something to be
But
done.
one opportunity, if your lordship observe, one opportunity before the learned court, he will appear and file an objection in the case.
No, we will say that after 38/2024, we do not find it to be a order either accepting the FR or
Rejecting the
rejecting the same.
That's a petition.
Therefore, now the petitioner seeks liberty to approach the trial court
To file
with
appropriate
an
appeal.
objection, to file an objection if any. And the trial court would pass appropriate orders, matter be listed again after, in the month of February, whereupon that order would be placed on record. You will do.
This should-
Then matters would be at your hand instead of the registry asking for the records.
Yes.
Okay. Heard Mr. S. Biswas, Learned Counsel, appearing for the petitioner. Also heard Mr. D.P. Goswami, Learned Counsel, Learned APP, full stop. The grievance expressed by the Learned Counsel for the petitioner the grievance expressed by the Learned Counsel for the petitioner on behalf of the petitioner is that by an order dated 38/2024, the learned Special Judicial Magistrate Kamrup Metro at Guwahati had tagged the status report in Dispur PS FR number 930 of 2023 dated 29/5/2023 along with the case records and the petition number 2695 was shown to be disposed of. It is submitted by the Learned Counsel for the petitioner that the petition number 2695 was with a prayer to have the updated status of the investigation earlier ordered by the trial court, by the Learned Court
On 8/12.
on 8/12
2022.
2022. Full stop.
Connection with dispute PS case number.
In connection with dispute PS case number
4048 of 2021.
2021. Full stop. The Learned Counsel for the petitioner has submitted that thereafter the petitioner has not been informed whether the final report has been accepted or whether he would be afforded an opportunity of raising objections against the same. Full stop. Today, after some deliberation, full stop, Mr. Biswas has submitted that the petitioner may be allowed, may be given the liberty to approach the court of the learned special judicial magistrate Kamrup Metro at Guwahati to file an application in connection with Dispur Police Station case number 4048 of 2021 after being after obtaining a copy of the final report stated to have been submitted on 29/5/2023. Full stop. On such objection being, no, the liberty prayed for is granted, full stop. On such objections filed by the petitioner, comma, the learned court shall pass necessary orders thereon. Full stop. Let this matter be listed again in the second week of February 2026, on which date Mr. Biswas shall inform the court as to whether the objections as per the liberty granted by this court had been filed and if any orders have been passed thereon. Full stop.
I'm being again, I think 27.
Yes, sir.
Lordship, this is an application for regular bail, Lordship. And the FIR is at page number 11, page 21.
21.
21, 11 page. Lordship, this is a commercial quantity, Lordship. There are 5 accused, Lordship. And what happened? In a truck was intercepted by police. And in a truck, some cylinders, gas cylinders were found. And inside the cylinder, the Yaba tablets were found. The accused were Sebul Hussain Laskar and Saidur Hussain Borvia. I am not. Thereafter, Lordship, on being asked, they said that they have also delivered 2 other cylinders to other persons. So police went there and police found Taramani Laskar and Motiul Islam. And contraband was also recovered from them. These are the 4 accused out of 5. As per allegation against me, that police has alleged that co-accused have said that they are also plan to go to me to sell the contraband and I will pay cash amount. Police went to my house and searched my house and police seized money, 8,90,000 money from me. I am constructing a house. I am taking this money from my relatives and other persons. And police found that money, seized that money and connected me in this particular case and no any contrabands. No any contrabands were seized from me. And I have not entangled in carrying all those contrabands by these other 4 accused persons, Lordship. The police has already submitted charge sheet, Lordship. 184 days. I am also behind the bar along with these 4 persons, Lordship. They have already, court has already submitted, provided copies to me, Lordship. None of the witnesses have said that any contrabands were recovered from me or I have any connection in respect of transportation of the contrabands.
What is your usual mode of livelihood?
Lordship, I am having business, Lordship.
What business?
Lordship?
Legal business, illegal business? What
No,
business?
not illegal business, Lordship. I am
What
having,
business?
This
Is the only business you have?
no, Lordship, no.
What is the other business? you have?
I am having business of this bamboo selling, Lordship, and other small shops, Lordship.
That is what we require to know because you 8 lakhs of rupees has been recovered from your house immediately after some people had named you to be the buyer.
Lordship.
Now, if we are convinced that that money was there in some lawful manner,
Lordship.
otherwise with bamboo and a few shops,
Lordship, so
8
far
lakhs
as
rupees at your
Lordship,
house, when other people are pointing fingers at you that we intend to sell it to him and he's going to give us cash.
Lordship, the only, there should be some other evidence, Lordship. Only on the basis of the co-accused statement, Lordship. So far, Lordship, your Lordship knows, Lordship, Tufan Singh judgment, the police cannot, the investigating agency cannot base only on the basis of.
Their part is gone. Now charge sheet is there. Whatever the police did is gone.
Yes,
Can we now let you?
even if,
have
Lordship,
a free
even
floor?
if this charge sheet is there, all the witnesses, whatever the witnesses.
How many witnesses examined till now?
Lordship, they have.
Yes, sir. What do you say? No contraband recovered from him.
But Lordship, he has been specifically implicated by the person's accused person also, and that Lordship, when huge quantity of money, huge amount of money has been recovered from his house, Lordship, and that there is no any explanation from his partners how it has been it has come, Lordship. So Lordship, commercial quantity is involved, Lordship. Then Lordship, section 37 will also come, Lordship.
Will come in. That is what.
Lordship, that money is not any sale proceeds of any drugs also. That money is not connected with this drugs, Lordship.
Show us.
One
Lordship,
person
That this money came from this place.
Lordship, all these witnesses, Lordship, Shamsul Islam,
No, no,
Portia,
no. You,
Nilal Roy.
on your bail petition, you show us that this money came from this place. 37 will go. Once 37 goes, we'll consider it to be a regular bail petition without the rigors of 37. No difficulty, yes?
And Lordship, one more thing is that Lordship, that 2% was first intercepted, and they told that this person another contraband is there that has been recovered. Then 4% told that they were supposed
Pyramid.
to sell it there. There they have got the money. So
Top of
Lordship,
the
all these
pyramid.
are the same is
Lordship,
Okay,
Lordship,
Yes.
I have the second legal submission, Lordship.
Please.
This, so far as notice for under section 48 is concerned.
That we will discuss after 1 hour.
Lordship,
To everybody's convenience, we'll discuss it after 1 hour
Lordship,
at 2.
Lordship.
WBC 1017/2022.
The notices dated 16/11/21, 25/11/21, and the termination notice are set aside and quashed. Since it has been stated that the work has already been completed, the respondents are now required to refund the security money and the performance guarantee to the petitioner expeditiously. Read petition disposed of to the extent indicated above. Some minor corrections, you'll have it by evening.
27.
Lordship, I have a submission.
Yes.
Lordship, I have done the petition, Lordship. We have not specifically ever in respect of the source of the money and which are seized. Lordship, this case may be listed in the first week of this after application, Lordship, and we may be allowed to file additional affidavit to bring.
At the prayer of Mr. So-and-so and counsel appearing for the petitioner, list this matter in the first week of January, by which time the petitioner shall be at liberty to file an additional affidavit.
A date to
First week of January, we have said they come and file it within this time.
Item 30.
Okay, my lord, is another court.
No issue, sir. Bonita. Yes.
This is question, my lord, your lordship. The petitioner, he is also advocate, my lord. And respondent 2017 when the marriage took place. They remained together about 7 to 8 months. One child was born. Thereafter, some sort of operation started because he was initially staying in the in-laws house.
Acha.
Thereafter, he had to come out and he started living in his own house. He has not come. Difference took place. Then I have gone to bring her. Then I have been assaulted by father-in-law. I filed a FIR. Thereafter, she filed an FIR against me. For 493, etc. my lord. Then again, my lord, father-in-law also filed a case against me. Now, my lord, I have married a second marriage, my lord, second marriage. And this was she filed another FIR. In this FIR, you also kindly the section. I'm just taking to your lordship to present FIR is page 83, your lordship.
53.
83. 83. Wait for. Page 29. This is the present FIR.
Yes.
Now kindly see page 29, my lord. Same allegation she filed earlier, page 29. Same allegation except second marriage part. Same allegation 10 lakhs, then 5 lakhs, same thing. That was already registered under 498 A, my lord. Now again, this case was registered. Your lordship will find register is 8582 BNS. There is section 4 of the Dowry Prohibition Act. So now 85, my lord, is a 498A. Earlier. 82 is, my lord, that bigamy. This is bailable. So that part is bailable. So far 85 is concerned, already she filed the case. And this is pending before the court. Now second case filed. That is the reason why I have come for crossing my. Same thing, my lord, same allegation, your lord, page 29. Your lordship will find. So far 498A is concerned. 85.
Now, thing is, which should proceed? You tell us. Both cannot be stayed because one has to proceed. Both cannot be quashed.
That was going on.
So since that was
Domestic violence was also going on. Three cases are now
but this
pending. One-
allegation of bigamy, how does it come in if we allow only the first one to go on?
No, relation minor when they are both community from the same community minor, both person. But this section is not attractive man. It comes only when if second marriage is minor boy, then in that is bigamy comes. If both the parties belong to same religion and if the religion allows minor, this is not boy. That is always judgment is there also minor. So far that point is concerned. So this is not coming. Even bigamy is there, it is bailable, what I am saying, madam. But here only 85 has come. Already there is a pending before 85. Same language, same allegations, everything is same. That is pending. 85.
What is the stage of the other one, the earlier one?
It is the stage of evidence, my.
Evidence. Yes, Mr. Goswami.
Yes, Lordship, it is in the earlier one was submitted, trial is going on.
Evidence, it is at the evidence stage.
Evidence stage.
And this one is the investigation stage. This one is the investigation stage.
So now if this, if action on this FIR is stayed for the time being,
Lordship.
let the other party appear. Because ultimately it is 498A on both the cases.
Yes, this is the case.
82 we shall see. For the time being, no proceedings in this one.
In page 83. Page number, my lord,
Page
Govipur page case number 474. 25.
Where do I find the number here?
Page 83.
Yes, FIR number 474, yes. Heard Mr. H.R. Chaudhary, Learned Counsel, Learned Senior Counsel appearing for the petitioner with the assistance of Mr. So-and-so H.R. Ahmed. The present petition has been filed under section 528 of the BNSS, being aggrieved by the registration of FIR. FIR dated 11/11/2025 registered as Gauripur PS case number 474 of 2025 within bracket GR number 1574 of 2025 under section 85/82 of the BNS read with section 4 of the Dowry Prohibition Act 1961. The senior counsel for the petitioner has submitted that the respondent number 2 herein had lodged an FIR before the Gauripur Police Station on
Uh,
22/3/2021, leveling allegations of demand of dowry and incidents which are relatable to offenses described under section 498A of the IPC, full stop. Accordingly, after investigation, a charge sheet was submitted against the petitioner herein, and it is submitted that the trial is at the evidence stage. During the pendency of such proceedings, the respondent number 2 herein had filed another FIR on 11/11/2025, which came to be registered as FIR number 474 in the Gauripur PS, leveling the very same allegations by adding only one further allegation that the petitioner had remarried during the lifetime of his first wife, full stop, by drawing attention of this court to the sections under which the aforesaid FIR had been registered, comma, Mr. H.R.A. Chaudhary, comma, learned senior counsel has submitted that it has been registered under section 85 of the BNS, comma, which relates to offences similar to the one for which the petitioner is presently being tried in, what was that GR case number?
335, man.
Huh?
335 India case number. GR number ato. GR number ato.
In FIR number 432 of 2021, full stop. The other sections added are.
438.
Huh?
438. 438.
438 of
Of
2021, full stop. The other section added, that is of bigamy, and section 4 of the DP Act are also incidents which have been investigated into in the previous FIR. Full stop. Mr. H.R. Chaudhary, Learned Senior Counsel, therefore submits that the second proceedings deserve the interference of this court. Full stop. I heard Mr. D.P. Goswami, learned APP, appearing in the matter, issue notice to the respondent number 2 by usual process as well as speed post. Full stop. Extra copies to be served on the learned APP within 3 working days. Steps for service of notice on respondent number 2 be taken within 1 week from today. Place this matter again on end of January, no, first week of February. In the last week of January, on a date to be fixed by the registry, along with service report on the respondent number 2. Full stop. It is provided that till the next date of listing, further proceedings in FIR number 0474 of 2025 in the Gauripur Police Station shall remain stayed. Full stop. Do go by.
Item to be three.
In DPS, my lord.
Sir.
On this section. Our only ground is 48 of BNS assessment. I just take to see one paragraph only, my lord. Then. Just. Only, my lord, your lordship kindly see that complaint Page 14, your Lord, kindness, page 1,
Page?
page 14. Paragraph 6. I
Yes,
must
sir.
say, madam, wife was informed by telephone. This is their case, madam. Paragraph 6, my lord, last year. And his wife was informed over phone about his arrest.
Where was he arrested?
Yes, he was arrested here. Your was kindly say 48, arrest. 48 is page 30, page 30, 30.
Page 30.
30.
Yes.
They're still on 17.5. 17.5.
From where?
Yes.
Arrested at where?
Oh,
In Silchar.
Silchar.
And the wife stays at?
Wife say Andhra Pradesh.
Andhra Pradesh.
So what is the quickest mode by which she can be informed?
Mail, WT message, or through the policeman. Nowadays, e-services.
Any statement made in the bail application that the mail email address
Nothing,
or
madam.
the WhatsApp numbers had been supplied by the accused to the arresting authority?
No, in my petition.
Where this
kindly
given?
say what I have stated, madam. Yes. You will find. Paragraph, my lord, 7. The petitioner begs to state, your lordship, paragraph 7,
Yes.
page 7.
Yes.
Petitioner begs to state that the grounds of arrest are not communicated to him nor to his wife. I am not now to him, my lord, to his wife or family members, and as such, there is a gross violation of so and so, so and so. So for the notice under section 47, that let us, it given in English, which the petitioner is not acquainted in as much as this somewhat he can write his name on English only. Only he can sign. He does not know anything more than signature in English. And hence on perusal of both the notice, it is evident that the ingredients of section 47, 48 are not at all attracted in this case, since the grounds of arrest so and so. Now I take to your lordship to page 30. Your lord kindly see, addressed to my wife. Your lordship got it one. And signature on the bottom, my husband's signature. That cannot be my lord. Husband's signature should be in 47. That was given to him. This was given to me. I must receive it and then I must acknowledge it. Then only it will come by. Now, your signature is here, my lord.
What we are trying to find out is when the lady is from
She is from Andhra Pradesh, my lord.
Andhra Pradesh,
Andhra
she is there.
Yes,
Person is being arrested here.
here at Silchar.
Information is to be given at least 2 hours prior, before production, before the magistrate.
That should be.
Now, how does the arresting officer ensure service in Andhra Pradesh?
So then they inform me also.
So he'll never be.
Madam,
So they
can have my phone
then all
number.
the arrest
They
in
can
such
have
circumstances have
phone
to
number
go.
for my husband.
Huh?
They can have my phone number, my husband number. Only thing is simply information.
No, that is why I had just asked
Yeah.
whether there is any statement in this bail petition that the WhatsApp number, email ID had been given,
Yeah,
but nothing was sent.
no, that.
If the accused or the arrested person says that there is only one phone number and the old one with the keypad, where do they send anything?
That I cannot say, but that I will have to inquire. That part
Because
is.
yes, true, the family has to be
It is
informed.
their duty to say, my lord.
How?
No, it is as per judgment of Supreme Court, my lord. It is their duty, my lord, whether I
When,
received or not.
when you are raising the ground of violation of Article 21,
Yes.
initially you would have to convince this court that you have done everything in your capacity to ensure that the right comes to you.
No, no, it is not my
Initially, it
duty,
has to be done.
not my duty, no.
At
Why
least
it-
up to the extent that you had informed them, this is where, please tell my wife on this WhatsApp number and this
It is
email
their
ID.
duty to inform my wife, my lord. It is their duty. It is
So it
their-
will not be at the time of the arrest or
but
immediate
I
production.
have
It
no
has to be
control.
later
I
on.
have no control. That part of course I cannot say, my lord.
We have to
That
be
part
reasonable.
in between the accused and in between the executive authority, my lord.
Yes, sir, what do you say?
That part I cannot say, my lord.
Whom did you inform?
Wife, Lordship, it is there.
How?
Through telephone. Number was provided by the, no, yes, Lordship, it is written there.
The telephone, they have written the complaint, but telephone instruction is not valid, my lord. That is what I am saying.
Have you filed your objections in this?
In one objection was filed, but subsequently they have taken another ground, Kotasri.
But this is the signature of the
Yes, Lordship.
arrested person.
He was arrested in Silchar
Hmm.
and the wife was informed through telephone,
Hmm.
number provided by the accused persons. So Lordship, the signature of accused.
Thereafter, how soon did you try to communicate with the wife to
Immediately,
give her the written?
Lordship, there is a not it is not city also, it is also informed that immediately she was informed. And there is a report from the Tripura's custom officer.
Hmm.
It is also, we have flagged mark.
Saying what?
Lordship, that the address provided by the petitioner are not, didn't find such address, Lordship. They said that they were not residing on that place. Lordship, report is there, I flagged mark, Lordship. Lordship, here, in this case, Lordship, final complaint was filed on 13/11/2025.
Hmm.
And case number is 11125
Hmm.
within a statutory period of 180 days. And
What is the recovery amount?
Lordship was 600,
That is, he was carrying, my lord, as a driver.
674 kg.
Consignment. He was to supposed to carry different consignment for different persons, my lord.
674 kgs of ganja were recovered from.
That is, I am not on that
No,
one.
if you are only on Article 21, we
Yes.
can keep this for Friday.
Right.
But you have to perhaps convince us to some extent that even when the arrested person does not say whom to inform, they would require to search it out. And if that searching takes some time and there comes a report that that address is wrong,
Yes, just so we
yet we can hold that there was a violation of Article 21 in this case also. But there, it has to depend on circumstances to circumstances. It
So,
cannot be on a,
so we may
cannot be a
compromise.
blanket.
Whether the address, because here address not given, only phone number is given,
It is-
wives of so and so, as mentioned by the.
No, he must have given his address when he was arrested.
Yes.
Some address he
his
has
address I
given.
have given.
So in that address, the tracing would be done. The report of the Tripura
Oh.
Commission, the Tripura has come, the report has come from Tripura that that person does not reside there. There is no such person.
Right.
What more can an arresting authority do?
No, if they have done, mobile number is there, my lord.
Huh?
So that mobile number, they could have traced it. Mobile number, they can trace out, my lord. So many avenues are there, my lord. They can trace out. Even the location, they can trace out.
I think that would be
Location
overburden.
is fine.
That would be overburdening the law keeping
their duty,
agencies.
man.
No, it is their duty, and to some extent, we find that the duty has been done to the best of their ability. Therefore, we'd like to keep
That
it
I
for
can
Friday.
collect, but address I can collect
Huh.
from the party, that I can.
What we can do is
But
we can,
Friday, my lord, I may not be available. one day.
your convenience, sir, no
Not
difficulty.
Any date, my lord, Friday, I don't, that is not possible.
Have it on Monday.
Yes, that can.
Have it on Monday. Because otherwise we find that they had done their best, and in such a
If
case,
they
we
have
cannot
done
say
their
that there
best,
is,
my lord, because my telephone number is there.
it is not good enough. It may not be good enough, but they have
No,
done
so
their
I
best.
am not saying that part is mine.
Yes. At the request of the learned counsel, appealing for the petitioner,
My lord, they have to file, that will be better, man, if they file some objection. I can
Already,
reply.
already we have submitted one.
No, no, that I
No,
want
where
to
is
know,
that
my
object-
lord, to whom they have served. To whom, which address they have
Last
served.
occasion, this honorable court directed me to obtain the
two-
certificate page diary.
One page, two page, my objection, let them file, my lord, so that we can reply also, man. Only
This-
that
When
part-
the allegation is that there were no attempts made, unless you come on record to say that these are the attempts made, would it not be difficult for us to pass an order?
You will file.
So we'll have it on Tuesday.
Then Wednesday,
Today is Wednesday.
because he has come from Silchar. Lord.
Huh?
Yes, the officer has to come from Silchar.
From Silchar.
He can come tomorrow also, what is the problem?
I think you
Wednesday.
can,
For me,
you
it's
can
a
get
problem.
scan copies, huh?
On 18, Lord.
18th. We'll have it on 18th, sir.
Next Wednesday, my lord. That will Tuesday, my lord.
Wednesday is 17. Choose 17 or 16. That is the 17th? 17th. At the request of the learned counsel for the petitioner, list this matter again on 17th. To stop the NCB.
No, Lordship, custom.
The customs would be at liberty to file their objections if so advised. Because that part we'll have to clarify. If it was a straight cut case, there's no difficulty. This part we'll have to perhaps discuss in the order.
Yes. That it will be better for resolution.
Kita baki ase. Time being, any, it's really kiman lage bol. Huh? Matoksun, 12 to Matoksun, bro. What is it?
But in this case, I may be permitted to take back those citation lists because it will take me around an hour to convince your lordship because I have taken out the printout of the citations. Some of the copies printers are not good yet. So my lord, I pray that let it come as a motion on Wednesday next because the matter is fixed before the trial court and the man is in custody. So I don't want to take it.
When is the matter listed next?
On Wednesday only. We in the morning we'll do it, then we'll inform the court of the outcome. 17th. So let it be listed, no, Monday, Tuesday morning, Kolkata.
When do you want it?
17 as a motion, let it come. Will not press
But
for
then,
the,
no, one thing will be there. If we allow this on 17th, then by the time we have the case, the witness.
no, I'm the trial court lawyer there. I'm doing the crossing. I'll not do it.
We'll trust him on that.
Yes.
On Wednesday, till the matter is heard here, we trust that you would not start the cross examination.
I'm correct. This I have to, my word, we can take it, my lord.
Regarding the summon,
Let it come as a motion because otherwise.
in the trial court, the summon is there.
Huh.
For the time being.
On
No, the
18th,
judge is very cooperative. my lord. When we made it-
on 18th, we are fixing it on 17th.
Yes.
On 17th. On 17th, even if you are from Guwahati,
Yes.
same area.
Yeah.
You would know what happens here in the morning itself. We'll take it up as early as possible.
Yes.
And in case we allow the proceedings to go on, appear in the afternoon or pray for a date.
Yes.
Pray for a date. That
pray for
we
a
will
date.
accommodate on the order itself. And if we find that the proceedings should not go on, we will stay. You need not appear.
Yes. And the court was.
Or can we have it on Tuesday?
No, 15, 16, the Monday, Tuesday, I'm in Calcutta.
Okay.
Even on the last occasion, even without a stay, when they said that we are moving the High Court, the court did not issue any warrant for because there was no stay. So it's not that, my lord, the judge.
On
is very
17th,
cooperative.
have someone there that
Yes.
the matter is being
Well,
taken
my
up.
junior will also be there.
Difficult for, because she is a minor, she will be going to.
No, you don't have to come. I assure you, I will not insist on the appearance.
Even
You don't have to
if
come.
we allow the proceedings there to go on, we will record in the order that you need not appear today and you will appear on the next date fixed.
Yes.
On Wednesday, take it to be an adjournment from this side of the.
Because I have also to summarize all the citations and the law. Because we had find out a.
I have only one doubt. I will make
Yes.
it very clear. Both
Yes.
of you can be prepared on that. I have only one doubt. Whether a re-examination or a recall of a witness will be allowed to fill up something which could have been done then, but was not done.
My lord,
Only on that part,
yeah.
sir.
There is a division bench judgment of
We'll look into it.
1972 of the High Court where it says that under 172 subsection 2, even both of us don't say about this contradiction or this. If the court has to look on the diary itself and have to point it out to the councils. And there is a judgment of the Gujarat High Court also. because,
That we will all look into
Yeah.
on.
That's why we'll summarize all the law and I will.
17.
Well, I may be permitted to take this list of citation. We'll-
citation thing দিছিলে নহয় আছিলে মই ফাইলখনত ভৰাই দিছো ফাইলখনত কি আছে লিষ্টখন যে আছিলে আপুনি বুটন দি দিছিলে তেওঁক ভৰাই দি দিয়ক
Because I doesn't want it after vacation because man is inside jail. So this.
sooner the better.
Yes. We are
At
blessed.
the request of the learned counsel for the parties, and at the consent of the learned counsel for the parties, list this matter again on 17th of December 2025 as a motion matter, since the proceedings in the trial court are fixed on that day.
We are obliged, Your Worship.
Item 21.
May it please your lordship, instructions were sought for. This pertains to a vehicle Zimma. It has been 7 months, 25 days. Twice the Zimma was rejected, your lordship. And the materials against the vehicle is that one person was apprehended with the drugs, which is
It
around-
was in your garage and
It
you,
was in my garage and I was not present. at-
vehicle in the garage, some few grams recovered.
Indeed, your lordship. Is this a vehicle for transportation of drugs or is it just my private vehicle? That is the matter here.
A private vehicle where the drugs could be,
Indeed, but the problem
where,
is they have not
where
mentioned
contraband can be.
that there is a secret cavity from where they have recovered nothing. Just
Yes.
We talked with the officer concerned and he's paying for some more time.
To do what?
For sending the report, lordship.
Which report? What report?
One report was called for regarding.
There is a vehicle which was parked in his residence where some amount of contraband has been found. That contraband amount, I think, is of
34
some 34 grams. We do not know the procedure followed by recovering the contraband. In any case, 7 months.
7 months.
7 months he has retained the vehicle.
Charge sheet has been filed.
Charge sheet has been filed. If the charge sheet is here, all you are required to show is that that vehicle had any chambers, any hidden spaces where it was, or from which part of the vehicle it was recovered, and how it will be helpful in the trial. If not, let him have this in my depositing the cost of the vehicle.
Regarding that part, lordship,
Ah.
can even if lordship may.
We'll accommodate you, but till when? He cannot
Day after
have
to-
that pleasure of keeping a vehicle.
Day after tomorrow, lordship, I will,
Day after
at
tomorrow.
least instruction I will bring, lordship.
Just we need to know why the vehicle needs to be retained. If there is any sort of allegation that that vehicle was being used, is being used, may be used,
Lordship,
with some reason says this is why we think so.
day after tomorrow, lordship.
We'll see what otherwise. Day after
Keep you.
tomorrow, at the request of the learned APP, come and list this matter again on Friday, to enable him to have the report as sought for in the earlier order. End of the day, if the vehicle is not found to be required, it's damaged for nothing.
Lordship.
Otherwise, if you do need it,
Lordship.
then we'll help it stay.
Lordship.
Much obliged.
Yes, Miss Bora. Yes, sir, what does the DP office say?
Records, we all have gone through, my lord. Nothing is reflected with regard to the final award pass, my lord.
Who was the person who was required to file the final award? Which is the office?
The arbitrator.
By the arbitrator. Was it referred to the arbitrator?
My lord, that's if your lordship come to, my lord,
Now, since there is no final award or anything, when his name was there,
yes, my lord, it
you
was.
did not, no challenge was made to his,
My lord, that's a fact, my lord. But with regard to the others, it comes around 5 lakhs, my lord.
whatever was in his favor.
5 lakhs, my lord, it was fixed at 2 and he has received already 3 lakhs 61,000, my
For
lord. The
him, where was it
record
fixed
says,
at?
my lord,
Where?
just a second, my lord. If he's anyway aggrieved with the ineducated compensation, only remedy is a reference, my lord. Saying that, no, since I am not made a party in that case, I should be given the 15 lakhs. Straightway the High Court, that is my objection, my lord. Because if your lordship go to the record itself, all 3 have gone through, my lord, including my senior friend also.
No, his, the award which was made in his favor is at 15 lakhs,
15 lakhs.
not varied.
Not varied.
Not
15 lakhs,
varied.
an appeal was made, my lord. Though he was not a member, not
That is,
made a
that
party.
is the, that is the whole problem. Though he was not a party, is the only problem we are facing.
My lord, at that relevant time, appeal could do.
At that relevant time, Lordship, no correction was made by the government. Only in the year 2012, Lordship record says,
Record says, my lord.
his correction was made.
That plot of
Earlier
land,
It was government land,
It was a government.
government land.
That was the problem.
then how could the award be made in his favor? How could the award come in your favor if the land was not in your name?
If your lordship comes to their own affidavit, annex sir 1 page 10, which they have annexed the award again, very interim award.
Hmm?
They say interim order, I say it is final award.
Their affidavit, when did you file it, madam?
Yes, I have given,
I have
No,
no
when
doubt.
did you file it?
oh, Lordship. See, more file করা নাই, নয় কি করবো। 31st of July 2017. Is this written?
Yes, we have it.
এই যে, it is 212, 212.
The lordship will kindly come to their internal page 11 of the affidavit, latest affidavit. Latest affidavit filed by them, page 11. How can they say it is a government land? Where from they get it?
Record says, Lordship.
Record arbitration award, why didn't you tell us this award if it was a government land? You didn't make me party also?
But it was corrected in the year 2012.
Anyway,
Now,
but-
Arbitrator says, Lordship, the commissioner says, Lordship, the name of Ghanesam Sati was inclusion of was found. How he can say? At the
Sarkar
time,
said-
correction was made. It is
recover
record
from
says,
the
this is
commissioner.
the record, Lordship.
You have to recover from the commissioner if he has made a mistake.
He has made a mistake because Lordship, he has said this were, this is a result of inclusion of land of Ghanesam Shetty under PP number so and DAG number 666. This was overlooked earlier. At that time, 25/9/2008, no correction was not corrected. Land record was not corrected. Only on 21/2012.
This
He
one
was
came
asked
on
to be,
25/9/2008
Yes.
Yes,
and you challenged in the writ petition, what did you challenge?
17.
17.
You never challenged 25/9/2008.
No,
This order of
said we have filed a arbitration case before the district judge, Lordship. 34.
against case number 4 of 2008.
4 of 2008.
And during the arbitration proceedings, you did not know that there was a case number 4 of 2008.
No, we have appeared, we have contested the case, Lordship.
Which case?
The appeal, Lordship, before the
no.
commissioner.
4 of 2008, you were represented.
Yes.
Yes. 4 of 2008, this order dated 25/9/2008.
We have challenged.
25/9/2008,
Yes.
where have you challenged?
Yes, we have challenged.
You have challenged the district court, Madam, order section 34. 34 doesn't lie here.
Page 18.
Yes, ma'am.
Huh?
Yes,
Writ petition, no?
Writ petition.
Huh? Yes, then why he was not made a party?
Because his name was not there in the
But it
land
was there
record.
in the order.
Order, yes.
Order, maybe,
His-
This is a result of the inclusion of Ghanesam
Sunset
Shetty, but
Tree.
they have find out that it was a government land, that has been overlooked. After that matter, land correction has been made, my lord. And he has given a PP patta, that is in 2012. The
12.
rec- the record says.
So this was overlooked
The order
earlier.
says-
Therefore, the total amount of compensation on the land allowed without the house and Gerard would be so and so being commercial land. So his name being left out, it was calculated at a lesser amount. After his land was included, it was calculated at a higher amount. Is that how do you understand it?
yes.
No.
No, Lordship, earlier it was 15 lakhs. The
Mm.
commissioner has.
That commissioner, when he passed that order, let us stay there for a moment. Let me understand this order.
Yes, yes.
I have to write about it. So before the commissioner, he said it is 15 lakhs
15 lakhs.
and during the fresh assessment, Circle officer found that as per land record, total area of land is 6 bighas.
6 figures.
1 kotha 18 lesa. Earlier, the total land to be acquired was 5
Five
bigha,
bigha.
0 kotha 18 lesa.
Yes.
The difference in this 1 bigha, approximately 1 bigha, 1 kotha, it came because Ghanoshyam Chetri's land was kept out.
Kept out.
Now, when his land was included in the acquisition process,
Acquisition process actually later on it was said by the commissioner lordship
where
that the second page lordship page.
that is what I'm trying to read.
Yes.
That originally 5 bigha was required to be acquired. Inclusion of the petitioner's land made it 6 bigha.
Yes. Yes.
So this order of 25/9/2008
Yes.
was specifically to the point that earlier it was 5 bigha. Now Ghanoshyam's land is included, therefore it becomes 6 bigha.
bigha.
Therefore now you are required to pay so much. Then you challenge this
Yes.
award.
Was-
This award was challenged, it was wrong. This order was challenged qua Padma Upadhyay, Puja Upadhyay, Vishal Upadhyay, Vasudev, Prem Prasad and Bina Devi.
Yes.
Although the order specifically says that Ghanoshyam's land is involved.
Inclusion of he was left out, but record.
The order was specific.
But
Madam.
because the record does not say so, lordship.
Did you file the appeal on the basis of the records which were there with
Challenge
the revenue, or did you challenge the order which had recorded certain facts? What were you challenging?
Look,
You were challenging the order of 25/9/2008 which included
Yes.
him.
Yes,
You chose not to challenge it qua him.
because his name was not in the record, that's why. How we can challenge
Because his name was in the order.
maybe lordship, that's why we have challenged, because his
Your
name
debt-
was corrected in the year 2012, lordship.
My lord.
How the commissioner says,
Let them.
how commissioner says his name was included, wrongly he has said, lordship.
No.
Yes.
Circle officer report. Read
Circular-
the order first.
Maybe circular way him,
Ah.
why he has written like this, Lord? It was corrected in the year.
Can you punish the circle in the commissioner? He says, my lord.
Corrected in the 12, lordship, how he can say, lordship? What circle officer has to give a report?
But during the fresh assessment, the circle officer.
Now
Lanka.
kindly come to page 21 of the writ petition.
Twenty-one.
The last paragraph.
Yes. Hence, the imperial order of the learned arbitrated, the commissioner, NAD is modified, shall get their value, land acquisition, so and so, at the value of rupees 5 lakhs per bigha.
No, is modified to the extent. Kindly read again.
Yes. Shall, hence the so and so is modified to
Ah,
the extent that opposite party number 2 and 5 shall get,
2 to 5.
2 to 5
So
shall
it is,
get the
this
value of
is a
their
judgment with regard to only opposite party number 2 to
2 and
5.
5.
Then
No, see, now he has said that his inclusion of Ghanoshyam Chetri, but how he can say it was not corrected in in that 2008 lordship? That is our problem,
see,
lordship.
if you keep
it's not
repeating,
there in the
if you
record,
keep
how-
repeating the same thing by which we are not convinced, if you are not coming up with anything formidable, we will have to reject your contention. If you are trying to say,
No, we have.
now, if you are trying to say that the relief was qua the opposite parties only while the valuation of the land was, let them discuss. Yes, list after the list in the 3rd week of February.
Hello?
You keep discussing within yourselves. We are not interested. Next matter.
If they do not require the.
No, you were more interested in discussing with her rather than listening to what the court was saying.
Hello?
We do not appreciate that.
I was not discussing.
Yes. Huh? Hmm.
Book under Posto 6. Book under 6 of Akko Ek Milo. this charge that matter, my lord.
Hmm.
LCR has been received, but TCR has been.
Service
received,
is
my lord.
awaited in this case.
Service awaited, my lord.
For a rejection, we need the service report to be complete.
My lord.
What is your age?
This, my lord, I'm below 16, my lord.
No, you are not below 16.
You are not, you have 50 years of age.
Victim is below
Petitioner?
16.
Petitioner is 50 years as per of
50.
50.
Petitioner is 50 years. School teacher, my lord.
List again on awaiting service report on the respondent number 2.
61.
612026.
Obviously.
Bill, madam, there was
Charge sheet submitted in this case.
Charge sheet is submitted. You'd like to try there?
Madam.
Yes.
I will approach Talbot, madam.
The learned PP, heard Mr. So-and-so learned counsel appearing for the petitioner, heard the learned APP has submitted that the case has resulted in a charge sheet bearing charge sheet number.
84/25 dated 28/11/25.
Full stop. The learned counsel for the petitioner prays that he may be granted the liberty to withdraw this writ petition, this bail petition and approach the trial court with appropriate application. Full stop. Liberty as prayed for is granted. On an application being filed by the petitioner before the learned trial court praying for bail, the same shall be considered on its own merits without reference to the present withdrawal.
37 is also same.
Thirty-seven.
7 is also same PSK charge sheet submitted in this case, along with this.
Same?
Yes.
Same order. Councillor नाम तो पहले लिखिए.
42.
42. Yes, sir.
Lordship have been in custody for the last time. Trial has been begun, Lordship. 6 witnesses has been examined. Altogether, there is 26 witnesses.
No, 13, Lordship. If I look in the charge sheet itself in the, because it is double, Lordship. Same name is there in the
So 13 witnesses, we take it.
13, Lordship.
And
Out
what
of it,
was the
7
quantity?
were over.
What is the quantity?
Quantity is, Lordship, 991.97 gram without plastic pouch.
991,
Lordship.
almost a kg.
Oh, it was, the amount of commercial quantity was 250.
Grams.
Lordship.
It's 991 grams, 4
991.
times.
Lordship, I'm will rely upon 2 decisions on that imposing stringent conditions. Matter can be disposed of, Lordship. And other is that guilty, whether guilty or not, how that has to be expressed, that has been explained. Lordship.
Since when are you?
23/4/25.
4,
Lordship, it
8
was
months. Huh?
charge framed on 21/7 and on 25/11, 7 is over, Lordship. It was quite good pace, Lordship.
6 more to go.
Oh, Lordship. No, already 7 has been gone. And there are 13 witnesses.
6
And-
more.
Oh, 6 gone, Lord, 6 gone, Lord.
6 more to
6
go.
more to go.
In Lordship 2024 1 GLT, the relevant paragraph will be 7, 8, 10, 16 and 17.
Young boy, 24 years, keeping him now behind bars, even if he is not guilty, he will turn into a guilty boy by the time he comes out.
But the embargo is also there, Lordship.
Embargo is
37.
there, but therefore this embargo, what was the quantity here, sir, in this case that you have given us?
Tomato,
1 kg, 1
Hmm?
kg
tomato.
nearby.
Prosecution case is that around 29 kgs of ganja.
Oh, in this case, Lordship, yes.
In one case, it was 29 kg.
And the other Lordship,
And in the other case, it was
16. No, this is methamphetamine.
methamphetamine.
This is methamphetamine, Lordship.
I beg pardon, Lordship, in methamphetamine, 50 gram is only there. And this is 900.
Nine fifty grams in Lordship in this 2024 two GLT, that is dimcianem case, it is Lordship 950 grams.
950 grams, almost.
Yaba tablets.
And in your case, what is it?
It's almost a kg, Lordship.
Same substance.
Same substance.
Yes. Yes.
In my submission, Lordship, he in a conscious position, it was found in his driver's
Was it
seat.
recovered from him?
Lordship.
No, Lordship, the witnesses, how they explain, even the informant, Lordship, his statement may can be seen, Lordship. PW3, what he stated. Page 36. Who recovered it? In his clause, he states that the statement of the seizure witness are identical by word and word. I did not allow myself to be searched by the independent witness before searching the vehicle. And the next, Lordship, I return back this also. In the exhibit P9, the CI of the Sonai put his initial but did not put date and time. Whether that will withstand the trial, Lordship, his own statement. That is section 41. That's compliance of section 41. That
It was recovered from the rickshaw, not you.
Not you, from the rickshaw. And even the seizure witness, Lordship, he stated that when I reached the place of occurrence, the auto rickshaw was parked at the place of occurrence. I cannot say prior to my arrival how much earlier the said auto rickshaw was detained by the police.
In PW2, Lordship, it is said that, may I read, Lordship? The occurrence took place so and so on the date of incident while I was passing over the road in my motorcycle. I saw a large gathering of so and so, Lordship. I went there and saw the informant so and so, and I saw that an auto rickshaw was parked and the accused person was sitting in the driver's seat. The said auto rickshaw was searched by the seizing officer in my presence, but nothing was found. Then the accused was open the dicky below the driver's seat. It was found, Lordship. And this is an independent witness, Lordship. Mason, yes, Mason.
Think we can wait for the trial. Let us wait for the trial. After the prosecution
only
witnesses
the-
end,
Only bread earner of the family, Lordship.
we'll ask for an expediting the prosecution witness part. And give you the liberty to come back once the prosecution witnesses are over. Who remain to be examined? Tell us that at least. Page 18.
Page 18, no, in page, Lordship. 18.
Page 18.
Page 18.
Ah.
There are one, Lordship, 9 is there, Manjul Haq, he is also an independent witness.
Okay.
And their Lordship, Ashok Kumar Gwala.
8 and 9.
Lordship. There are 2 independent witnesses are also there, Lordship.
And get them examined as quickly as possible.
Lordship, it can delay now. Within the space of 4 months, Lordship, they have already examined 7 witnesses.
7 witnesses, they are
It
doing
is
it quickly.
quite a great pace, Lordship. A good pace.
Pass the order.
CD received.
No, Lordship, scan copy.
Scan copies.
Scan copies here, where? Oh. ऐसे नहीं scan copy. Wait for it. The independent witnesses,
In condition, Lordship,
Huh?
that's what Justice Chaudhary has stated in his.
Lordship,
Order.
37 has to be, embargo has to be satisfied. Lordship, embargo of 37 has to be satisfied.
that he has not
That
committed
has-
the,
Lordship.
he has not
That-
Not
committed it.
guilty.
That has been
And-
explained by Justice Barua in his judgment. That has to be, that's reasonably has to be interpreted. It is not that, in fact, if a court says that he is not held guilty, the trial will be persical one, Lordship. So at the very initial stage, your Lordship will not draw whether guilty or not. Only
You
the
sitting-
reasonable conclusion. That
You
will be-
found sitting on the same
Lordship.
seat under which it
Lordship.
is found when it is
Lordship.
your rickshaw.
Lordship.
How far can we reasonably say that yes, perhaps
Because the
not?
witness has said that, I didn't know what has been written in the seizure list. PW1 statement, Lordship. Lordship may reserve the order, Lordship may go through these two decisions, thereafter
Okay.
pass the order.
We'll
Thereafter.
pass the-
Lordship
We'll pass the order.
Deeply order.
চেম্বাৰ দিম তোৰ। কাইলৈ ৰাতিপুৱা পাই যাব, আজি লিখিম।
Commercial quantity, my lord.
Hmm.
That's already framed, my lord.
Huh?
That's framed already.
Charges framed,
Framed.
commercial quantity.
Yes.
Why the bail now? How many days?
My lord, on 19/7/2025.
Hmm?
19/7/2025.
Your Lordship, that is tramadol.
Huh?
Tramadol is there,
Hmm.
1.715 kg, Lordship. 1 kg, 715 gram. And moreover, Lordship, there are 11 witnesses are there. And on 17/11/2025, search frame.
Wait for some time, let
Lordship.
let the independent witnesses go.
Lordship.
Let the independent witnesses go.
They can approach in the trial court, Lordship. It may be disposed of now.
We'll dispose this off now. At this stage, we are not
Mhm.
granting the bail.
Not-
We'll allow you to approach the trial court for bail once the prosecution witnesses are done with. Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard Mr. So-and-so learned APP, full stop. This case has been instituted praying for bail under section 483 of the Bharatiya Nagarik Suraksha Sanhita. In NDPS case number 25 of 2025, arising out of Mahur PS case number 9 of 25 under section 22C, full stop. The quantity of contraband recovered is of commercial quantity. And it has been submitted at the bar that the charges have been framed on 17/11/2025. 17th?
Lordship.
When was the
One-
charge? No. When was the charges framed?
Oh, Lordship.
Charges were framed on so and so date?
Charges framed on 17/11/2025, Lordship.
We have heard the learned counsel for the parties and gone through the case records. Stop. At this stage of the trial, we are not inclined to grant bail to the petitioner, full stop. However, the petitioner shall be at liberty to approach the trial court after, for praying for bail after the evidence of the prosecution witnesses are closed.
Liberty to approach the trial.
We have given that liberty to approach the trial court. We should not say prosecution case. Okay, cut out that line. Petitioner would be at liberty to approach the trial court.
Obliged.
Yes,
This matter, your lordship, it's a 483 application. There, the FIR, your lordship will find page 9.
34, no, I think. 34. In this case, Lordship, this is a POXO case, service completed. We have received, Lordship, service completed. So otherwise,
we'll
amicus will
appoint
be
an
appointed.
amicus and have it when?
Has to
On
be
any date,
next week,
Lordship?
because otherwise, this
Next week
boy
is-
is actually higher secondary studying, his exams will be next February. So he's a science student from, though POXO is there, the whole issue is with regard.
Miss Srimati Pooja Agarwal. No, I think it is Dr. Pooja Agarwal now. Dr. Pooja Agarwal is appointed as an amicus curiae in the matter. Learned counsel for the petition to serve a copy of the petition on Dr. Agarwal. So please this matter again on
17th or 18th.
18, Lordship.
18th,
Lordship, CD is there, so it need to be retained.
Yes,
then.
CD may be retained.
18th full stop, the CD received by the, 18. 18 बहुत matter. It's too much. 18 is too,
17, Lordship.
17,
Seven.
16,
Seven.
huh?
17.
17?
Yes.
17.
17, Lord, 17.
8 to 17 last matter করব। On 17th.
Lord.
Obliged.
Made.
Yes, sir.
Lordship, regular bail application, Lordship, 166 days in jail custody, Lordship. POXO 12 is there, Lordship, but FIR, Lordship, will find on page 14, Lordship. The girl is a 17 years and this present petitioner is 21 years. Now, Lordship, I may take you, Lordship, the order, rejection order that is on page 25, Lordship.
Just a minute, we have not even finished reading the FIR.
That Lordship will say, allegation against Asima Begum.
Yes, yes, we need not have the names announced. Yes.
Then Lordship, can they come to the page 25, Lordship?
Huh?
Bottom part of the 25, Lordship. On receipt of the notice, the informant and the victim of the case has appeared before the court and has filed petition number such and such to the learned special PP stating therein that they have no objection to the bail prayer of the accused, Minhajul Islam, that is the present petitioner. Even then, Lordship, this bail prayer of this petitioner was rejected by the court below, Lordship. Now notice has been served, Lordship, probably.
You are appearing.
Yes, my lord.
Now, Lordship, here what happened, Lordship, one person is absconder. Now, Lordship, when he will appear, it is not uncertain, Lordship. Now this petitioner is 166 days in jail custody, Lordship. Their parents, Lordship, now parents are ready to, Lordship, settle their marriage, Lordship, because this girl is only.
That will be decided on Monday whether we interfere when the parents agree to marry of minor children. That we will
Because
decide. on
17
Monday.
years, Lordship, because that's why she and her guardian, that is the informant, Lordship, filed the petition before the court below, Lordship. They have no objection to grant bail, Lordship.
May I please, your lordship, lordship, the informant as well as the victim, they were they are outside in the court today, lordship. We have filed Falatma today itself, my lord, on their version. They were amicably settled the matter, and marriage will be solemnization between the victim and the informant.
What is the age of the victim now?
Victim age is 17 years at the
Now,
time.
as of today? As of
17 years,
As of today, 17 years.
17 years, my lord.
17 years plus.
We will have the mother, the person bringing the instruction, everybody inside.
The mother.
You are suggesting a 17-year-old agrees to a marriage and you are making that
After
submission in
the
the.
attaining the age of majority, my lord.
Eh?
After the age of majority, my lord, marriage will be solemnized, my lord. Matter was amicably settled between the parties, my lord. The order-
21 years boy, Lordship, and that they have, Lordship, some relation is there.
What do you say?
Because the victim is, her frequency indicated the petitioner. This firstly submit 10 PWs are there, such not can be because one.
If we allow bail in this matter where the victim had earlier implicated and now she is made to say that, okay, I will marry him.
Marry him.
There appears to be some pressure on her. So is that fine? Sir, what is the statement given before the magistrate?
One, that I have annexed, Lordship.
I have
page-
segment on the 180.
Huh?
I have segment on.
Oh, yes.
Page 21, Lordship, in my petition. And the case was registered under Lordship section 12 of the POXO, that is sexual assault where punishment is 3 years, Lordship. And along with Lordship 64 and 140
subsection 3 of the BNS lordship. In 143 lordship subsection 3, it is 7 years, and 64, that is the rape lordship. Now, rape and lordship, the sexual assault lordship, there is no penetration part.
Stop. This bill petition has been preferred. By the petitioner praying for grant of regular bail under special P case number 94 of 2015. It would be, it is submitted that in the FIR, the respondent number 2 had alleged that the accused had picked up his daughter aged about 17 years on 31/3/2025 afternoon at about 2 p.m. and the daughter was returned back at about 5 p.m. The daughter had then informed that 2 boys had taken her to a certain place and committed bad work on her. Full stop. Later on, the accused were on identification were named in the FIR. Full stop. It has been submitted by the learned APP that the matter, it is charge sheeted. That the matter has been charge sheeted and the trial is going on.
One person is absconding, that's why search is not.
Or, sorry. Huh?
Has it not to me?
Charge sheet has been submitted, but due to the absconding of one of the persons, the charges have not yet been framed. Full stop. The learned counsel for the petitioner submitted that the boy is that the petitioner is a young boy of 21 years and there is a romantic relationship with the victim. Full stop. Keeping in view the young age of the petitioner and the relationship established, he prays that the petitioner may be allowed to go on bail, more so in view of the fact that since one of the accused is absconding, it cannot be imagined as to when the trial would commence or would conclude. Full stop. The learned counsel appearing for the respondent number 2 has submitted that he is under instructions from the respondent number 2 that the parties have arrived at an amicable settlement where the informant number, where the respondent has instructed him that, should we record that or not?
Recorded.
That they are ready to allow the petitioner number 1 and the victim to enter into marriage when the victim attains the age of majority. Full stop. Learned APP has vehemently objected to the bail, to the prayer for bail, citing that the victim is still a minor and in view of the fact that initially when the FIR was lodged and even while making a statement before the learned magistrate, she had implicated the accused. Full stop. Therefore, he submits that releasing the petitioner on bail at this stage may allow him to influence or coerce the victim. Full stop. This court has considered the submissions made by the learned counsel appearing for the parties. Full stop. The records reveal that in the FIR there are specific allegations of luring the victim child to a place in Arunachal. They took her to Arunachal.
Yes, Lordship, coming.
To Arunachal, where she was confined to a hotel and physical abuse, including slapping her, etc., had taken place. Full stop. There are also allegations of penetrative sexual assault on the victim. Full stop. On the statement made before the learned magistrate also, the victim had made similar statements. Full stop. The medical report of the victim also suggests ligature marks on the neck and abrasions on the neck and bleeding in the private parts. Full stop. taking an overall view of the matter, comma, this court this court is of the opinion that the statements of the minor victim are being influenced by the circumstances the statement that the mindset of the victim may be influenced since now the father of the victim girl has also proposed marriage when he had initially complained of assault against his minor daughter, full stop. This court at this stage does not think it fit to allow the petitioner to be released on bail, full stop, as there would be at this stage, full stop, bail petition accordingly dismissed. Published.
Six. Whatever the actual course, maybe next week.
Why?
Madam, one instruction is required from my client.
What instruction? Material instruction?
One document, my lord, because I am a mechanic, my lord.
You are a mechanic?
Mechanic.
Yes.
I have been implicated in this case
Hmm.
by even mistaken facts. Because, so my lord, the mechanic identity card should be recovered from him because he is in my tax, man. He is in my tax, he will give this man, his guardian, madam. So sometime required, maybe next week, madam.
It was recovered from you, the
Nothing. recovered.
contraband allegedly.
It is alleged, madam, but it is a totally mistaken fact, madam.
At the prayer of the learned counsel for the parties, list this matter again
Next week.
in the next week.
CD is there, Lordship, then we need to.
The CD, will that retention do or do we need to call for an updated next week only?
Updated, then.
Updated CD, it will come. The APP may arrange for the updated CD in the meantime. Yes. Next week বুলি কৈছো আজি fix কৰা you don't do the time পাই দি দিব. Yes, Mr. Sheikh.
CD was for.
We have not received a case there yet.
What is
Not-
the allegation?
CD not.
Not received.
That allegation, your lordship will turn to FIR page 11, madam.
How does that one sentence wage war against
My
India?
Humble submission before your lordship.
Ah.
Actually, some forced, my lord, it is not specific. যে বিহাৰত হাৰি যাব গতিকে এইটো বম ব্লাষ্ট কৰিছে কোনে কৰিছে
No, where is the bomb blast part?
মানে
Why are you adding to the statement?
বিহাৰত সিট
Making it more dangerous for you. Why are you adding to it?
স্যার
Read what is
বিহাৰত
written.
সিট কম পালে বাবে এতিয়া নাটক আৰম্ভ
Where is the bomb blast?
my lord বিহাৰত সিট কম
You are
পালে বাবে
tripping them.
এতিয়া নাটক আৰম্ভণি
Yes, tell us. There is some particular law by which you can keep him away from this kind of activities. Is it necessary to keep him behind bars like this,
that I have completed
investigating whether he put it up or not?
Yes.
That he put up, that is a almost an accepted fact.
27 years my lord in custody and another thing is this my lord what materials objectionable materials that has been already seized my lord. My lord, where is the ground that I have OS war 147 my lord I OS war against the state that is the allegation case registered under 147
That is what we are saying, Mr. Goswami.
Lordship.
He put it in the social media.
After the read.
Verbal media, many things are going on. Your jail should be too full with people. If he's a real threat, you have provisions of law to deal with it. Should we continue to wait for the CD or take a call? It is your choice.
We'll put a CD on.
Already 27 days gone.
my lord,
31, 37 years old person
given
for a sentence Slip of tongue, no slip of finger. A slip of finger, what to do?
For CD, my lord, time was given, sufficient time was given, 7 days time. It is from Komolpur only, my lord.
We are
Not
heard Mr. M.S. Sheikh, learned counsel appearing for the petitioner, also heard Mr. Goswami, learned APP appearing in the matter. Full stop. This is an application praying for bail of the petitioner who has been languishing in jail since 24/11/2025 in connection with Komolpur PS case number 145 of 2025 under section 147, 148, 152, 196 within bracket 1/353 within bracket 2 BNS read with section 67 of the IT Act. Full stop. No, we learned APP was required to call the case diary was called for on 2/12/2025, but the same is yet to be received. Full stop. The allegations level in the FIR is that the petitioner had dropped a comment in where
Facebook.
Huh? Where?
On Bibli Bandhana is saying Biharot Kompale Babe Etia Nato.
In a Facebook profile.
Where do we bring Facebook in from? Show us.
In his profile name, Monoar photo, phone number.
All social media has profile name, sir. Which social media? Which site?
It was recovered from Facebook profile link.
Where?
www.facebook.com, Lordship, Monua Photography. It was a page 11, Lordship, accused details.
Mobile phone bearing IME one number.
Mobile number is that, after that, Lordship, Facebook profile link.
Why don't I find? Okay, alleging that the what did I say? Alleging that the petitioner had dropped a comment in social media stating Bihar seat kompale babe etia natok arambhoni. Full stop. Due to the said comment, the petitioner had been arrested and the offences as shown in the FIR were under section 147 BNS waging or attempting to wage war or abetting waging of war. Number 2, section 148 BNS, conspiring to commit offences against 147. Page 11 pencil mark. Mr. M.H. Sheikh, learned counsel for the petitioner, has submitted that the petitioner is a young boy and the comment given in the Facebook has no relation to any particular happening. Stuff. He has submitted that the petitioner has already spent 11 days behind bars for his such comment.
27
days.
27 days as of today for his such comments. Full stop. He therefore prays that in this circumstances, the petitioner may be released on bail. Full stop. Learned APP has vehemently opposed to the prayer for bail, stating that these kinds of comments, if allowed to be circulated, what was that used? Would be derogatory and inflammatory against the government and hurt the sentiment of public of India. And it has also acted as an insult to the innocent victims of the blast. Full stop. He has prayed for rejection of the prayer for bail. Full stop. We have considered the circumstances in which the petitioner had been arrested, and we have also applied our mind to the allegations leveled against him. Full stop. In the this court is of the view that the petitioner may be allowed the privilege of bail at this stage, since all evidence are electronic. And the authorities have also failed to produce the case diary as called for, full stop. Accordingly, the petitioner is directed to be released on bail on furnishing a bond of rupees 20,000 with a surety of a like amount, subject to the satisfaction of the
My lord,
officer in charge, Komorpur Police Station. Huh?
Regular.
Hmm?
Chief Judicial Magistrate.
Of the Chief Judicial Magistrate.
First class. Sorry, my lord. So
Of the Judicial
first
Magistrate
Kam-
First Class, Rongia Kamrup.
Hongya.
Rongia Kamrup. Full stop. Give the usual conditions. It is further provided that the petitioner shall not use any communication of any social media for a period of at least 6 months. Full stop. 6 months from today. Advise him, he should stay away from all kind of social media, including WhatsApp.
I will.
Let him have some rest. Let the fingers rest. He can rest at home.
Already rested for 27 days. Most obliging.
Supplementary again, bail hearing here, item 54.
Please, Your Lordship,
Yes.
Regular bail application in section 6 of OXO. The service report on respondent 2 was awaited, Lordship. Instructions were.
Respondent number 3
On 2.
of 2.
Right, on.
So services completed lordship and amicus.
Will appoint an amicus,
Lordship.
Yes, sir.
huh?
Lordship, yes, Lordship.
But it has to be on the first week of January at best. We are overloading the court, huh?
We expect here is Lordship, there is a co-accused who is absconding.
Hmm.
So the trial has therefore not progressed. And it was charge sheeted in December of last year. So 353 days.
We will take all that into consideration when we take up the matter in
First week
in
of
January. Huh?
First week of January.
First week of January, na? Learned EPP has submitted that the service on the respondent number 2 is complete. However, none appears for the said respondent today. Miss Priyanki Das is therefore appointed as amicus in the matter. Learned counsel for the petitioner shall serve a copy of the petition on the amicus curiae. List this matter again in the first week of January. When I did it? When? First week of January would be 7th of January 2026. নাকি বেশি হয়েছে 7 of
55.
55 also, so instruction was sought for, we have communicated that, but service is not completed yet, so they have gotten, they have received the notice, lordship. But they will.
whether
Fix
they
the
have
date of
received
January,
notice.
lordship, is can, ECR has been received, lordship, so we'll try to. Service complete one, I, paise.
Without service complete, we cannot.
Yes, yes, that's the one.
Hmm?
Next week, my lord.
Next week, any problem? So list of January.
Next week is some motion day. And all these matters, if we fill up the board with these matters, then on those days, where will the mentions be fitted in?
Again, they will not come again, my lord, amicus curiae append also. Otherwise, my lord, on the next week, if
We can
Mr.
keep it
come,
on
my
the
lord,
for.
that they have received the.
We have communicated, but he has,
Yes, my lord.
all the police personnel were alone detail lordship, that's why they have to, cannot provide the service.
And last occasion also, my lord, Mr. Thomas soft for.
The duty will be over next week or this week.
Today I have communicated one
Huh?
with the OC concerned lordship.
We'll have it on the 5th of January on the, immediately on the reopening day. And if we have to appoint an amicus, we can take up the matter at the end of that week itself. If you want.
Okay, end of this week.
Because after appointment of amicus,
Yes,
not much time. Service report on the respondent number 2 is awaited, full stop. Place this matter again on the 5th of January,
Next week, my lord,
2026 for
otherwise
service report, huh?
have a try on next week, Lordship, because my lord, on that day, at least amicus will be appointed, Lordship.
The one phonetic here and there, you can try and will be tired. The list which comes up, if we overburden it, we will not be able to pay attention to anything.
Well, after that, I will share maybe call for TCA.
Fifth, we'll take up the matter, and
Well, TCA, after that.
ninth, we will decide your matter. huh?
Up to the TCA maybe call for, because in the meantime.
Up to date PCA.
Because, Lordship, already, Sassit already, already, my lord filed. In the meantime, if the informant or my lord. the
Charge sheet
victim
filed on
examined-
13/11/25.
Yes.
So almost 1 month.
If
What
it-
will be the progress of the TCR? Only the case diary part will be there.
Yes, Lord, if in the meantime, my victim examined, then it will come, Lordship.
Then already issue reminder for.
Your client would be, your client would be knowing. Inform us on the next day. If you make a statement in the court that yes, this part of the prosecution has taken place, the evidence has taken place, we'll take your word for it.
Lordship, Lordship.
Why should we disbelieve you when you make a statement at the bar? We will not disbelieve you.
Lordship.
It took a number.
55.
It took 55, it took 56 this happening. 56.
I'm on that.
Offense under Forest Act, my lord.
Hmm.
Petitioner is behind the bar for 33 days.
53 days.
33 days.
33 days after killing how many animals?
No, my lord, only 3 kg, my lord, of
Huh?
pangolin skin, my.
Oh, you
Now,
only have the skin.
Now, my lord, in this case, on last occasion, my lord, I produced here before, shown one thing, my lord, page 18.
18, 1/8.
1/8, my lord.
Uh-huh.
1/8 of the bill petition, my lord. This is the 47 notice, my lord.
Hmm.
Lordship, on the first day when I referred before your lordship, so it was the lordship, that letter mentioned that the reference at Roman 2, my lord. This is regarding my lord Caesar list, my lord. My contention before your lordship that in any point of time prior to production, the 47 notice was not furnished. And my lord, kindly have a look, this notice, my lord, nowhere date is mentioned, my lord. Even in the forwarding letter itself, my lord, in the enclosure, my lord, it is not mentioned that 47, 14, page 16, my lord. Enclosures mentioned, my lord, 47, 48 notice has not been mentioned, my.
No, illegal collection and trafficking of pangolin skills 3 kg approximate. The ground is there. So you are saying that it was not served upon you.
My,
Then when did you sign it?
no, my lord, my contention, my lord, it was the signature after being taken into custody, my lord. Blank signatures were taken, my. And my lord, if they have at all, my lord, it was as per the recent judgment of Apex Court, my lord, it is required to be furnished prior to 2 hours before the production, my lord. Now, my lord, forwarding, kindly have a look, page 1616, my lord. These are enclosures, my lord. Last at the bottom, my lord. Offense report, Caesar list, Caesar report, Jimmanama, statement of accused person, medical report, seized materials, that is so and so. Now, my lord, if it was at all, my lord, furnished, they could have.
Yes, section 47 notice is not in this.
Perhaps, my lord,
When was he arrested? Half long. You are a resident of where?
Kachar,
Kachar.
my lord.
You should not be seen near the forest for the next 6 months. For any reason whatsoever. Do you agree to that?
Lord.
Eh? You should not be seen near these forests for the next 6 months. We have given one not to go to the social media.
My lord.
You will not go to the forest, whatever
Lord,
be the
Lord,
reason.
Lord.
Yes.
That have
72
to
years.
be-
One is 72 years old, one is 20 years, one is 22, one is 32.
Right.
Different generations. Family business. Yes.
That issue, perhaps I have to cave in because that this forwarding doesn't mention 47. That
Not,
has to.
not only that, the absence of the date adds to it. On page 18, the absence of the date, at least your officer could have signed it on a date.
16, 17, 18 to put page it. Yes, sir, this kind of copies, my copy is not legible also.
Same with me. But if you see, even your arresting officer has not put his seal and signature on the part where the signature of arresting officer should be there. He's put it on some other
My lord,
area.
my lord, I understand.
Is it, will not,
Certain pockets of our state, my lord. Lordship, without on merit, my lord, Lordship will perhaps allow and put some stringent conditions.
yes. No, but
47
you
is
could
his
say,
right. my lord.
the age
Yes,
72
but
and 20
47
years.
is his right. my lord. Section 40.
Section 47, the notice under section 47 does
47
not
is
inspire
mandatory.
confidence. Yes, take down. Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard Mr.
D-
D. Gogoi learned
Special PP for wildlife. my lord.
special PP for wildlife protection. Full stop. This petition has been filed seeking bail in connection with page number 1 or second paragraph logo, huh? Full stop. It has been, it is submitted that the petitioners were arrested on
My lord, 7/11/20.
7/11/2025. Full stop. The FIR indicates that certain amount of pangolin skins were found in the possession of the petitioners herein and had been recovered and seized. Full stop. Huh? The learned counsel for the petitioner has submitted that the forwarding report of the petitioners do not indicate the notice under section 47 of the BNSS does not indicate that the notice under section so-and-so had been served upon the petitioners. Referring to the alleged notice under section 47 BNSS, the learned counsel has submitted that the same do not contain any date. Full stop. He has submitted that there is a reasonable apprehension that the petitioners were not served the notices in accordance with law. Full stop. He has also submitted that the petitioners, the two of the petitioners are aged 72 years and 20 years respectively. Full stop. In view of all the above, he has prayed that the petitioners may be granted the privilege of bail. Full stop. Learned special public prosecutor appearing for the Wildlife Department has submitted that the petitioners have been arrested in connection with recovery of 3 kgs approximately of pangolin scales, and releasing them at this point of time may hamper and temper the investigation, and there is no assurance that the petitioners would not indulge in such kind of activities again. Full stop. We have considered the learned submissions made by the learned counsel for the parties. We have also gone through the records produced before us. Full stop. In the facts and circumstances, we deem it fit to allow the privilege of bail to the petitioners. Mainly 1, 2, 3, 4, huh? Petitioner naam kita di dibo. 1, 2, 3, 4 in connection with AFR case number so-and-so, subject to their furnishing a bond of rupees 15,000 each with 2 sureties of the like amount for each of the petitioners respectively, subject to the satisfaction of
Session judge, my lord. District session judge. Dima.
District and Session Judge Dima Hasan.
Session judge.
District and Session Judge Dima Hasan. Full stop. The petitioners, baki kita condition di dibo bailer, they will not leave the district, or they will not, they will not. They will cooperate with the investigation. Yevo ekhane di pelai. Eta dibo that the petitioners shall not engage in any forest related activities. Any forest related activities during the time they remain on bail.
Should be special judge.
Special judge perhaps.
Special Judge
Special
Dima Hasan.
Dima Hasan.
Dima Hasan.
Oblige.
Tell them not to go near the forest. Or should we add that it can be revoked? Should we add that? If they are found near the forest, it can be revoked.
Yes.
How near? That will be another question. Yes.
Item 57 and 58. Hello. FIR is at page 18, Lordship.
Page 18.
18, Lordship.
Hmm.
May I read, Lord? সম্মানপূর্বক বিনীত নিবেদন এই যে আজি 28-10-25 তারিখে 8:45 বজাত মই মোৰ জাহাজী শ্ৰীমতী অমুকৰ পৰা জানিব পাৰো যে মোৰ 17 বছৰীয়া নাবালিকা ছোৱালী মিছ বিবস্ত্ৰ অৱস্থাত থকা অশ্লীল ভিডিঅ' সামাজিক মাধ্যম হোৱাটছএপ
Sudden leakage of those photographs after a long lapse of time would not attract the provisions of the acts referred to in the FIR. Full stop. The learned APP has submitted that it is an admitted position that the victim is a minor girl, and given the ages of the accused oblique petitioners, there is every possibility that they may try to influence or hamper or tamper with the investigation if released now at bail. The learned counsel appearing for the respondent number 2 has also submitted that the petition, that the victim being a minor girl may be under a threat of coercion, duress, or influence if the petitioners are at this stage released on bail. Full stop. We have considered the submissions made by the learned counsel for the parties, and we have also gone through the updated case diary as produced before us. Full stop. Having regard to the materials on record, we do not find this to be a fit case at this stage of the investigation to consider grant of privilege of bail to the petitioners. Full stop. Accordingly, this bail petition is rejected at this stage on the basis of the
trial court on some further development of the materials.
at this stage, full stop. The dismissal of this bail petition would not bar the petitioners from approaching the court in case of any other development. Any future development, please.
Obliged. Item 59.
Your Lordship. Submitted, my lord.
We are on interim law.
We'll continue the interim. Appear there.
Only allegation is against the petitioner's lordship, they have adopted a child without following the prescribed procedure. That is the allegation.
No, it is not about adopting, it is about buying a child.
Yes, lordship,
Hmm?
but
Who filed the FIR?
FIR lordship that was filed with the child.
What about the parents? The
Parent?
biological parents?
Lordship, biological parent, they have lordship written a letter that we have handed over our child to you. So that
No, no
as well.
consideration of money in that. No mention of money or anything.
No,
Nothing.
Nothing, lordship. Only a written note they have executed.
And what is this bail order already annexed?
That was earlier rejected by the learned.
Huh?
Lord. That bail order, lordship, initially granted the interim to us, lordship, and subsequently, lordship, our bail petition was rejected by the learned court.
Oh,
Anticipated bail. Lordship.
how old was the child?
15 years old.
Infant, lordship.
Huh?
Infant.
No, regarding
No,
adoption
child
of
was
the-
an infant.
No,
He's
page
saying
20,
15 years.
Page 20, 15 years.
Page 20.
Page 20, in this case, part of the record. In this case, the. FIR
Adoption of a 15-year-old child. 15-year.
Lordship, perhaps that might be mistake, because as per my instruction, this is a new infant child.
Huh? 15 months maybe. I don't know.
Because Lordship,
Somewhere there will be a statement. Huh?
I have also personal relation with my client, Lordship. So
Hmm.
as they have no boy child, Lordship, and as per doctor's advice, Lordship.
Then it should be appreciated, Mr. Parashar, someone trying to adopt a girl child. Huh?
My lord.
Yes, this FIR, does it say anything, the age?
Yes.
Rule of 15 days.
15 days, Lord.
15 days approx. My lord.
That is not for labor. 15 days child, how can you put in for labor? The judge has rejected it down below, saying that it is.
But he has calculated 15 years out.
That is what they have said is exploitation, recruit, harbors, transfers, received any person or person by using force, abduction, practicing fraud, deception, including giving, receiving payment in order to achieve consent for having control over the person recruited, transported, harbored, transferred, or received. None of these apply to a 15 days old.
Maybe cut and paste order, my lord. Sorry to say, my lord. 15 days. Okay, my lord.
Should they go there or should they have a relief here?
My lord.
Huh?
My lord.
Relief? Heard Mr. Sorenson council appearing for the petitioner also heard.
Already in interim, already as per interim, they have appeared.
There was an interim order, no?
They will
Heard
be.
Mr. Sorenson council for the petitioner also heard Mr. Sorenson council, learned APP. The allegations against the petitioners as reflected in the FIR is that they had adopted a 15-day-old child, an infant, without following the due process of law relating to such adoption, full stop. This court, after considering the materials available on, after considering the submissions made, had by order dated 37/2025 allowed the petitioner to the protection of an interim bail by directing them to appear before the investigating officer of Hailakandi Police Station in connection with Hailakandi Police Station case number 68 of 2025. Full stop. It is submitted today that the petitioners have appeared and their statements have been recorded. Full stop.
Already charge sheeted, my lord.
The learned APP has submitted that the case has been charge sheeted. Full stop. The learned,
CS number 104/2025, dated 26/8/25.
The learned counsel for the petitioner has submitted that the petitioners would be ready to participate in the trial proceedings and also ready to follow any conditions imposed upon by this court. Full stop. The submissions made in the records have been perused. Full stop. This court is of the view that the petitioners are entitled for grant of for the privilege of a pre-arrest bail. Full stop. In such circumstances, the bail granted on 37/2025 is made absolute. Stop. Anticipatory bail petition disposed of.
Hello.
59.
They appeared. Last occasion, they said they had appeared. You were supposed to take some instruction.
I
Have
have
they
taken-
appeared or not?
No, they have appeared, lordship.
They have appeared.
I have seen, lord.
What to do now? Absolute. 62-year-old
Lordship.
and 21-year-old.
Moreover, these are the persons, lordship, they are only the members of the society and they have not, I have seen, lordship, and they have not generally asked the persons collected. They have not collected. Other persons are there, they are president, vice president, They mainly collected, Lordship.
Okay.
Against this specifically, these persons have not asked any person. They are only the members of the society. Otherwise, they should not have done this because under the
They should not have formed a society, they should have not have started the business.
And they have not taken money from the persons, public,
Okay.
Lordship.
None appears for the petitioners on call. Heard Mr. So-and-so learned additional public prosecutor for the state of Assam, full stop. By the order dated 792025, the petitioners were granted the privilege of bail in the interim by directing them to appear before the investigating officer of Khetri Police Station. Investigating officer, to appear before the investigating officer in connection with Khetri PS case number 56 of 2025. Full stop, the learned APP has submitted that he has instructions that the petitioners have appeared and their statements have been recorded. Full stop, he has submitted that for the time being, the custodial, don't say it, he has said that. In view of the above, this court is of the opinion that for the time being, the custodial interrogation of the petitioners may not be necessary. In such view, the bail granted by this court on 17/9/2025 is made absolute. A be disposed of. Yes.
Oh, those item 40.
ঠিক আছে চাৰিটা পাঁচটা ছটা Yes.
Lordship, I may be taken for suspension of sentence and bail laws.
What was the
Lordship, here, these applicants were convicted under 376(2) and 379 and 10 years imprisonment and 3 years.
So may I plead, Lordship, here in this case, TCR received, Lordship. So Lordship can finally dispose of this matter on any other date, Lordship.
Judgment of 24, they are in custody, they are carrying out the sentence.
Lordship.
Judgment is of 24, 1 years. One matter, 3 years, we have fixed in February. We'll keep this for February, let him go through the TCR. We'll hear the appeal itself. For a month, why consider? Learned counsel for the appellant has submitted that the interlocutory application has been filed praying for suspension of the sentence imposed upon the petitioner by the order dated 26/12/2024 in sessions case number 97 within bracket NL of 2014 by the court of the additional sessions judge within bracket FTC, Lakhimpur, not Lakhimpur, full stop. The learned APP appearing for the state has suggested that the entire, since the trial court records have been received, the entire appeal may be taken up for consideration in the month of February, by which time he would be prepared. Full stop. Accordingly, list this matter again on February. Choose a date. Choose a date on February.
Lordship,
On 7?
7th of February.
Not 7, Lordship, 5th, Lordship.
5th of February 2026. Full stop. Learned counsels are requested to be prepared for final consideration of the matter. You are appearing for?
I am the amicus panel. The registry may be directed to furnish me the copies of the evidence, madam.
The learned counsel, the learned amicus curiae shall be furnished with copies of the evidence in the available in the TCR by the registry.
Madam.
Item 41. Okay, as per official update 6.
Yes.
2025.
Service of notice upon the respondent number 2 is awaited, so it's directed to through the office of public prosecutor. Jurisdictional police officer.
Yes, sir. Any?
We have not received the instruction, Lordship.
Yes, this is a 482.
Washington.
What is your ground?
Your lordship.
What
this
is
one,
wrong?
Lordship, they are a petition, joint petition, lordship. Joint petition.
Yeah.
Foxo matter lordship passing not.
On that ground, we are rejecting it today itself. Forget about waiting for. On that ground, we are rejecting it. Nothing doing. Supreme Court stops us. Foxo matter, no compromise,
This
no
is the
nothing.
one judgment of apex court also.
What? Which one?
Yes.
This will be interesting
I think I.
if you can change. It's good.
Lordship, in this file, I have not, let the matter of the upper two.
Huh?
I'll put us.
No, it goes after the, goes after the winter vacation. List this matter again, this service report is not there. List this matter again in the, again in January. January দিয়ক data চাই পেলাই হা এতিয়া কিমান আছে চাই লওক on 22nd of January 2026 awaiting service report on the respondent number.
There is an interim order.
There is an interim order.
Stay.
Doing what? Staying what? Acha.
Then lordship-
Interim order passed earlier shall continue.
Then lordship may fix it some earlier lordship because it is stay is going on lordship.
No issues. Let the stay be there for some more time.
What is-
You be prepared with your materials. You are having ample time. Be prepared with your materials to convince the court. Rest assured, they are prepared to convince the court. So this is only an opportunity to you to be prepared. Yes. Man, it item? 42 years.
Yeah, please, your lordship.
Hmm.
Lordship, we had taken steps for the second time upon the informant.
Hmm.
On the first time, it had returned with a comment that addressee is out of station. But for the subsequent steps which we took, his service report is yet to be awaited.
Service report on the respondent number 2 is awaited, comma, even as the learned counsel for the petitioner submits that they had taken steps on.
But,
Second time, when did you take it, sir?
my lord, it should be 26/11, 2020.
On 26/11,
2025.
2025, full stop. List.
My lord, a small submission. May an amicus be appointed because of the
Without,
deteriorating health condition of.
without this service being complete, either unserved or something, we cannot do it. It has to be served. Before we can appoint an amicus, we'll put it up in the, in January last week,
My lord,
27th of January 2026.
my lord, may it be taken up on the first, 7th of January if possible.
That will be immediately on the reopening. Again, the court should be full.
But-
Right, 7th of January. The 7th of January 2026. Awaiting service report on the respondent number 2. 43.
Well, can you have a look on the last order, my lord? On 28/11, my lord. Oh. Well, in this court, my lord, it is recorded that respondent number 2 is the victim. No, the petitioner is the victim, my lord. Respondent against acquittal of the POCSO court, my lord, we challenge them. So, inform.
No, what, come again?
My lord, he has come against acquittal. He is the victim.
I'm the victim.
Oh, court recorded that he's the accused.
Yes. Therefore, my lord, the service for the respondent is all complete. He has not represented, my lord. You know, delay.
I am the amicus, my lord.
Yes.
I have checked, my lord, it's 300 something delays.
388.
We condone the delay?
It can be condoned, my lord.
We condone the delay, we'll take up the connected appeal, na?
Not
It
yet.
has been submitted by the learned counsel appearing for the petitioner that in the previous order dated 28/11/2025, an amicus curiae was appointed to defend the interest of the minor victim. Full stop. He submits that this was perhaps because of the oversight, that this is an appeal filed by the victim against an order of acquittal. Full stop. Accordingly, let the order dated 28/11/2025 be read as appointing the amicus curiae in the interest of
Interest will be victim.
Huh?
Victim. Victim interest lordship has appointed him as amicus curiae, my lord. Right person lordship has, my lord, that's unfortunate.
Might be, my lords, now,
no,
perhaps, he's the accused,
Accused.
accused, the acquittal who has been acquitted.
No, for accused, we are not putting on anybody, sorry. Not for anybody, full stop. What did we say that last sentence? As according? As appointing Mr. D. Gogoi as the amicus curiae to assist the court. Full stop. We will not remove him.
Yes.
Let him do some homework.
Yes, my lord.
Then you write this interlocutory application has been filed. Praying for condonation of delay of 380 days in filing the accompanying criminal appeal. Full stop.
Paragraph 4, I have stated ground, my lord.
The grounds on which the applicant depends to justify the delay have been incorporated in paragraph 4 of the interlocutory application. Full stop. None has put in appearance for the respondent number 2. Full stop. In view of the above, the delay this court is of the view that the delay has been appropriately explained by the applicant, full stop, and deserves to be condoned, full stop. Accordingly, the delay of 380 days in filing the connected appeal is condoned, full stop. Registry to list the connected criminal appeal accordingly. Criminal, IA criminal disposed of.
Deeply obliged, my lord. Thank you. Yes.
Yes.
Correction of the cost title, lordship. Petitioner-
Correction of cost title.
That is the address of the petitioner, lordship. I have written PS Katigora Institute of Patarakhandi, lordship. District Kasar Institute of Sribhum.
No, I did not understand. What did you say? PO dash one instead of PO more. Oh, you did not enter the this is what a criminal petition. The amount of correction to be made, sir. Those forms which you had filled up. How will you change them?
Yes, burden date.
No, the forms that were filled up with the revision to the auction. Any stay operating? Huh?
Bill granted, lordship.
Bail was granted.
Disposed matter.
Huh?
Disposed.
Disposed matter. It is all the more difficult. PO, it should be PO.
Moina.
Moinul Haq, 29 years, Asaddar Ali, PO blank, police station, Katigora, district Sribhumi. Okay, we are not allowing the correction of the cost title as such. We will not allow the correction of the cost title because the cost title cannot be corrected as of now. We'll pass an order in this interlocutory application that in the final orders shall relate to. Because now if we allow it in a disposed matter, how can we allow a correction in the cost title? You are changing the very description of the petitioner. When was it disposed of? 2011.
This, Lordship, this matter will be, maybe listed before the
Appropriate bench.
Lordship. Because that court has passed now.
Hmm?
Because
And this is not on the merit of the case. That is what we were seeing. He was only allowed to go and appear before the JMFC, Sri Bhumi, where he would be released on bail and allowed to participate in the trial.
then
That was the order passed.
he has got the relief, no?
Huh?
He has got,
He has got the relief now because of the wrong address. He is not being able to utilize that relief. Something like Korno, who knew all the weapons but could not remember it. That is what has happened to him. We can just correct that. We can just observe that this is an application moved. And this application will be read in connection with so and so who claims to be the petitioner, and that there was an error in the cause title. We can add the two together and go and place this order before to be read along with that. Or should we put it before the appropriate court? Let us send it before the appropriate court. He will pass that order whether it is to be read along with or not. This matter has been, this IA has been filed by the petitioner, bring for correction of the cause title of, tell us, Mr. Goswami. Or should we dispose it of?
Earlier, Lordship, it will not entertain, Lordship, dispose of by Shaikasar court. So later may be fixed on Shaikasar court.
That is what? Interlocutory, has been filed seeking modification of the cause title, full stop. The matter stood disposed of on, the connected criminal petition stood disposed of on 2011-2025, full stop, registry to verify and place the matter before the appropriate bench. Yes, sir.
Lordship, we have taken steps upon the respondent number 2, who is also the informant. As per the office note, services awaited. LCRS call for has already been received.
Yes.
service report awaited. Service report awaited, Lordship.
Service report awaited.
Lordship, the matter may come after 4 weeks and the interim order earlier.
List the matter after 4 weeks on a date to be fixed by the registry, awaiting service report on the respondent number 2, full stop, interim order passed earlier shall continue.
Item 60.
Yes.
Say that neither the output says that neither the ID card nor the answered notice has been returned. Step was taken through registered post on the respondent number 2. Lordship, I may be allowed to take a fresh step and liberty may be granted me to collect the postal receipt from the registry and to file affidavit in the courts so as to confirm that service has been completed. Otherwise, the trial will start, Lordship.
Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard Mr. So-and-so learned APP. The office note reflects that the service report on the respondent number 2 is neither AD card nor unserved notice has been received back by this section till date, full stop. The learned counsel for the petitioner has submitted that he may be allowed to take press steps on the respondent number 2 and be further permitted to file an affidavit showing the status of showing the track report by collecting the status from the concerned
Postal track.
Postal, the concerned postal department, full stop. Prayer is allowed. Petitioner may take fresh steps on the respondent number 2 within a period of 10 days from today. List the matter again after 4 weeks on a date to be fixed by the registry, and the petitioner would be at liberty to place the postal track report before this court in the form of an affidavit by the next date fixed.
Such is the
16, where is it? Huh? 61.
Hey, please, your lordship.
Yes.
In this case, lordship, as a service report is awaited, lordship.
Yes, sir. Any interim?
No interim is there, lordship. Here this petitioner, lordship. Dragon 319, lordship, now it is a 358, newly added accused, lordship.
List in the third week of January on a date to be fixed by the registry along with the service report.
Highly obliged.
1046.
Yes, sir. You have got
Some accommodation.
4 minutes. Yes.
Submission one.
Huh?
I can make a submission, my lord, about the story about the matter. my lord.
করিবা নি করা যদি করা মনে আমি পড়বো
This is of 2014.
14, my lord. The judgment order dated 22/7/4, my lord.
What is the sentence?
Sentence, my lord, 7 years and with fine 5,000, my lord.
NDPS Act 14/7, how many years?
7 years with fine.
14/7,
My lord, this is
any stay?
convicting the accused person under section 2020B, my lord.
7 years was the sentence.
7 years.
Any stay given? No.
No,
He must have been in and out. 21, he should have been out.
yes,
He's at home,
yes, he is at home, my lord.
but this will take time.
Yes, my lord. And the informant is, my lord, eye of the police, my lord. And that has not been served, my lord. That can be taken by the government also, my lord, by the state also.
To the PP. Huh?
Informant is the eye of the police, my lord,
Ah.
service report.
in service report. That has been awaited long back, my lord.
We can take, you can reprint.
The learned counsel appearing for the petitioner has submitted that the service report on the
Respondent number
informant. That is respondent number
2, my lord,
2 is
eye of
shown-
the police, my lord.
eye of the case has been shown as awaited.
Awaited,
Full
my
stop. The learned APP has agreed to enter appearance on behalf of the said respondent, full stop. The matter relates to the year 2014. In view of the above, list the matter again on.
14 হবে?
Yes. Choose a date.
Last week of January, my.
Last week of, we'll have it on the first week of February.
my-
First week of February 2026. Since there is paucity of time today. Yes.
1047.
God bless me.
47.
2014 revision now, why?
You please, your lordship,
Huh?
I'm humbly seeking for an accommodation today.
Why?
Lordship, on the last date, the counsel for the petitioner had mentioned the brief was taken from him. And the petitioners today telephonically instructed me to appear in this case. But unfortunately, I have not received the brief yet.
Okay, Mr. So-and-so learned counsel,
G. Kaushik.
Mr. G. Kaushik, learned counsel, appearing for the petitioners has submitted that he has telephonic instructions to appear in the matter and he prays for an accommodation to be allowed to file the wakalat nama on behalf of the petitioners, full stop. The matter is of 2014. Was challenged. Defamation. Let this matter be listed again in the second week of February,
Interim-
2026.
Interim, there is an interim one.
Huh?
Interim, 2014 interim one. 12/12/2014.
The interim order passed earlier shall continue. Yes.
Much ago.
48.
Huh? Yes, sir.
It's under POSCO Act, my lord.
Hmm.
Judgment of 2022, my lord.
Ah.
Been in custody more than 3 years, 2 months. The additional law, my lord.
Hmm?
She was 16 years and he was.
But then, Mr. Potoki, paucity of time would
I
perhaps
understand.
not allow us to take it up today.
Additional law recently Supreme Court has also.
What about the, this thing?
It was completed. I mean,
Service completed, you are appearing.
I make it clear.
So when can we have it?
Subject to your lordship's convenience.
Immediately on the reopening?
Yes, naturally.
So next week would not be possible immediately on the reopening.
The IAS is still there, but it has not been rejected as yet.
Oh, no, trial court records are here,
Yeah,
yes,
yeah,
trial
trial
court
court has been
records are
rejected.
here, therefore, heard Mr. P. Kotogi Learned Counsel appearing for the appellant. Also heard the Learned APP and Mr. So Learned Counsel appearing for the respondent number 2, full stop. The trial court records have been received, full stop, at the consent of the parties. Instead of addressing the IA criminal, filed for suspension of the sentence, comma, since the trial court records have been received, place this matter again in the first week of February 2026 on a date to be fixed by the registry for considering the appeal on merits. Full stop.
Date fixed by the registry.
Yes, I've said first week of February. Because if we keep fixing all the dates for hearing, it becomes difficult for them. The hearing list becomes too long. So now I don't think they take up that part 2 list, do they? There is no part 2 list. They have to adjust everything in this list only. First, thank you.